Good evening. I'd like to welcome all our friends to this webinar of the Article 16 focus group. My name is Mohan Gopal, and I'm very happy to welcome you on behalf of this informal group of lawyers, former civil servants, academia, civil society, young people, researchers, and others who have come together from across the country as a think tank, as a think tank, in order to strongly defend our fundamental right to reservations under the Constitution, under Article 15, under Article 16, as well as our right to political representation in Parliament and in the legislature, and to deepen and widen these reservations as a very important instrument of social change and social justice, the significance of which we will have an opportunity to speak about later on during this event. We are particularly committed to defending what we see as three fundamental rights contained in Article 16, deliberately and carefully and conscientiously put in there in the Constituent Assembly by our founding fathers. The fundamental right to equal opportunity in matters of public representation, fundamental right to adequate representation in public employment and in public institutions, and our fundamental right to reservations as a means of ensuring these rights to equal opportunity and adequate representation as a constitutionally prescribed specific mechanism, carefully thought through, carefully debated, and carefully enshrined in the Constitution as a specific instrument of social justice. This includes, of course, also the rights of the SC/ST to promotion, which had to be rightly codified directly in the Constitution after the Indira Sawhney decision narrowed reservations only to initial appointments. The Constitution was amended to include 16(4)(a) that protects the rights of scheduled castes and scheduled tribes at the minimum to reservation and promotion. We have seen in the last 15 years after the decision in Nagaraj, a organized and systematic attack not only on reservations in general, but on the right of scheduled castes and scheduled tribes to reservations in promotion under Article 16(4)(a) of the Constitution, which has been narrowed in a number of decisions, which we will discuss in more detail as we go forward. We're very, very proud and delighted to have with us a very distinguished panel of speakers today to guide us into these deliberations. Starting with Madam Indira Jaising, one of the most distinguished jurists and lawyers of our country, a person of unmatchable experience and commitment and record in her service to justice in this country. And also, more importantly, in the recent past has emerged as a lone voice amongst the senior members of the bar, a lone voice defending reservations in case after case in the Supreme Court, and sometimes doing so without even expecting or taking remuneration where it is necessary and unavoidable. She is a person who is contributing a lot to this fight, and we're very happy to have her here with us. Equally, we are very proud and happy to have Advocate of the Supreme Court, Dr.K.S. Chauhan, who is another very important warrior in the legal fight, constitutional fight for social justice, defending the reservations in a large number of cases, and ensuring that the legal defense of this constitutional right is robust and strong. We're very, very happy and proud to have him with us. We are also delighted to have with us Justice Eshwaraiah, a former national chairperson of the National Commission on Backward Classes, former Chief Justice of Andhra Pradesh High Court, very distinguished former judge and jurist, and a person who is now leading as the president of the All India Federation of Backward Classes, a person who has again been in the forefront of the struggle to defend the interests of the backward classes, a friend, philosopher, and guide to all of us. We have also with us a very distinguished chairman of the sitting chairman of the Kerala State Scheduled Caste and Scheduled Tribe Commission, Mr. B.S. Maoji, who is also again a very distinguished figure in the struggle for social justice. We're very proud and happy to have him with us today, and we're very proud and happy also to have with us Madam P.K. Santhamma, a very distinguished advocate in the Kerala High Court, again a person who has courageously stood up for the rights of the weak and the oppressed and for social justice in the High Court of Kerala, and continues to do so. We're very proud and happy to have her with us. We're also delighted to have with us two young, bright new stars in the field. Mr. Professor K.S. Vidyuth, who teaches law at the Kozhikode Government Law College, and is again a very active leader in the cause of social justice. And we have Ms. Disha Vadekar, who is also a young advocate in the Supreme Court, already very actively involved, initially under the mentorship of Madam Indira Jaising, involved in these issues on reservation and fight for social justice. So we have a very interesting panel, and we'll have a discussion at the end of this. We look forward to a very, very important discussion. Our main objective in organizing this is very clear. The judgments of the Supreme Court, as we have seen, are sometimes right and sometimes wrong, and sometimes corrected by themselves, as we have seen in many cases, including the ADM Jabalpur case. But our understanding of the law, the people's understanding of the law, and the understanding of the law of legal scholars must be objective, must be truthful, must be valid, and we must evaluate the judgments of the Supreme Court against our own understanding of the law. So we must understand what is the correct law on social justice, on reservations, of the Constitution, as intended by the father of the Constitution, Baba Saheb Dr. B.R. Ambedkar, and his colleagues from the social justice movement, who fought against grave odds and created a unique constitution, unparalleled in the world, with a very rich set of provisions of social justice inside that constitution. We must have a correct understanding of the Constitution so that we can judge the Supreme Court's work, which may go this way and that way, against a correct understanding of the Constitution. And our argument to you today is that some of the Supreme Court's decisions narrowing down Scheduled Caste, Scheduled Tribes' right to reservation promotions are, in my view and in view of some of the others, wrong. And we hope that, like ADM Jabalpur, in the course of time, it will get corrected. But we must know why it is wrong, what is wrong with it, so that we have the correct understanding. We, the people, the Constitution belongs to us. We must have a correct understanding of the Constitution as far as we are concerned, based on law, based on correct principles of legal interpretation. So that's what we will offer to you. Before I request Madam Indira Jaising to start the proceedings, I would like to take 2 minutes to give you two snapshots, one from history and one from a recent judgment of the Supreme Court. The history that brings us all together here clearly is the history of the development of our social justice provisions in the Constitution. While the Constitution was being enacted, two scheduled caste members of the very distinguished scheduled caste members of the Constituent Assembly, Sri V.I. Muniswamy Pillai and Sri S. Nagappa spoke to the Constituent Assembly on the 27th and 28th of August 1947, the 12th day of our independence. Mr. Muniswamy Pillai said, "Sir," I'm quoting now, "Sir, there is a fear in the minds of some of my friends, especially the scheduled castes, that the Hindus are coming into power." He means upper caste Hindus. "And that Hindu Raj is coming into force. And they may introduce the Varnashrama that was obtaining years back again to harass the Harijans." This is what Mr. V.I. Muniswamy Pillai said 12 days after independence. We were very happy that the British had left. We were, due to the struggle of the Dalits and the common people of this country, we were very happy that India had won its independence. But on the 12th day of independence, Mr. Muniswamy Pillai informed the Constituent Assembly in a speech that there is fear in the minds of some of my friends, the scheduled castes, that the Savarnas are getting into power and Hindu Raj is coming and they may introduce the Varnashrama and take us back, years back, to Varnashrama to harass the Harijans. Mr. Nagappa, his colleague, also scheduled caste member of the Constituent Assembly, a very distinguished member also with many rich contributions to the Constitution. Mr. Nagappa said, it's a slightly, few lines more intervention. He says, "I would suggest that it would have been better if it has been provided in the Constitution that a particular community will have its share according to its population." So Mr. Nagappa said, "I want every community to have its share according to its population." And he says, quote, "I do not want to rob Peter to pay Paul. It is very bad policy. I want my due share." And then Mr. Nagappa says, "Although I am innocent, I am ignorant, I am dumb, yet I want you to recognize my claim. Do not take advantage of my being dumb. Do not take advantage of my being innocent. I only want my due share and I do not want anything more. I do not want, like others, weightage or a separate state. No one has a better claim than us for a separate state. We are the aboriginals of this country." So Mr. Nagappa told the Constituent Assembly, "Give us our due share or give us a separate state. But we don't want to be taken back to Varnashrama Dharma, and we don't want to be taken back to the order where we were treated as less than human beings." This was the demand that was placed, that we want our due share because it is our claim, not because it will lift us out of poverty, not because it will advance us to the so-called state of the upper classes and upper castes. God forbid if we were to be like that. That was not the basis. It was not for development, not for representation, not for any of these purposes that are being used in order to justify reservations. Mr. Nagappa said, "I want my due share because it is my claim. Because I'm an Indian, I want my claim." That's what he said. Now, in contrast, I will just end by quoting to you a sentence from a 2018 September judgment of the Supreme Court on this issue of SC/ST reservation and promotion. And that is Jarnail Singh and others versus Lakshmi Narayan Gupta, 26th of September 2018 judgment. And the Supreme Court says, according to us, the Nagaraj judgment has wisely left the test for determining adequacy of representation in promotional posts for scheduled caste, scheduled tribes to the states, for the simple reason that as the posts get higher, now this is the important point that the Supreme Court is saying a few months ago, for the simple reason that as the posts get higher, it may be necessary even if a proportionality test to the population as a whole is taken into account, to reduce the number of scheduled castes and scheduled tribes in promotion posts as one goes upward. A shocking statement from the Supreme Court. It says, according to us, it may be necessary to reduce the number of scheduled castes and scheduled tribes in promotional posts as one goes upwards. This is for the simple reason that efficiency of administration has to be looked at every time promotions are made. As if the increased number of scheduled castes and scheduled tribes will reduce efficiency. This is what the Supreme Court is assuming. As has been pointed out in Indira Soni, there may be certain posts right at the top. The reservation is impermissible altogether. Why? What is the basis of that, other than pure casteism? For this reason, we make it clear that Article 16.4a has been couched in language which would leave it to the states to determine adequate representation depending upon the promotional post that is in question. So the main source of resistance is they do not want scheduled castes and scheduled tribes in the highest positions of the country. And that is the purpose of the resistance, but that is also the purpose of creating this republic, that the common people, the poor people of this country will occupy the highest positions of this country. So please see the contrast between the fear of Mr. Muniswamy and Mr. Nagappa in 1947 and the view expressed in 2018, 71 years later, by the Supreme Court, which has not learned the lesson, has not yet heard the voice of Muniswamy and Nagappa. And please tell me, is there any other instrument except reservation that will force this insensitive, deaf, and blind elite to recognize and hear the claim of Muniswamy and Nagappa? With this, let me turn to our first speaker, Madam Indira Jaising, and request her to kindly address us. We are looking forward very much to hearing you. Madam Indira Jaising. Let me unmute you in case you're unmuted. Sorry. Yes, I think you should be unmuted now. Yes.
Can you hear me?
Yes, we can hear you.
Okay. At the outset, I wish to thank you all for inviting me to this very important webinar. It is my pleasure to be with you today. It's about being with the community of people that you identify with, and this is what makes me very happy. And I am going to share with you just little snippets of what actually happens in a court of law when you represent the SC and ST community. I have something written out, but before I go to that, let me tell you that as recently as 28th of May, 2021, I was appearing in the High Court of Bombay through video conference in a matter which I will talk about at some length on behalf of the SC and ST community. And you will not believe it, but I was not even allowed to address the court. My voice was drowned out by a good many male lawyers. I happened to be the only woman addressing the court, who effectively prevented me from addressing the court on my petition, where I had the right to audience, and all these people were representing the unreserved category, or what we call the open category, or what we call the upper castes, as interveners. So what I want to tell you is that there are strategies used by people who represent the upper castes or the upper castes which are not just legal strategies. They are strategies intended to demoralize you. They are strategies intended to drown your voice. Their strategies intended to put you down because you happen to be a woman, and there is no end to what you see in a court of law. You are very comfortable here in this webinar. You are in a safe space, but you try entering the space of the courtroom because they know that the outcome of a case in court can change the course of our lives for the better. Now, having said this, I want to uh, go straight to the issue at hand. What is the immediate provocation for me to be at this webinar today? It was precisely the recent notification issued by the state of Maharashtra on the 7th of May 2021, which took me by complete surprise. The effect of that notification was that all posts that were reserved for the scheduled castes and scheduled tribes that were to be filled up by promotions from the reserved category were abolished, and henceforth promotions were to be done strictly in accordance with seniority, being determined on the date of recruitment into the service. Along with this sudden development, I raised the question as why would this be done in the year 2021 and on the 7th of May 2021? Only one answer presented itself to my mind, and that was on the 5th of May 2021, only 2 days before the Supreme Court of India had struck down Maharashtra government's flagship program of giving reservation to Marathas in the OBC category, significantly on the ground that they were not backward. Was this then an act of revenge? This is a question that many people in Maharashtra are asking. Do the SC and ST communities have to pay the price for the Supreme Court striking down reservations for Marathas? It
मैं
was an
एक
act of
पूछना चाहता हूँ
appeasement. It was an act of appeasement, in my opinion, intended to tell the Maratha community, look, all these posts which were hitherto reserved for the scheduled caste and scheduled tribe will now be available to you in a general category, which we were not doing in the past. So this was the politics behind it. And there was more to the politics because when the reservations were made for Marathas in Maharashtra, it was a BJP government which was in power. And they had succeeded in having their law upheld in the High Court. This law was challenged in the Supreme Court and struck down. As I said, one of the grounds for striking down was that the Marathas are not backward. And the other ground was that after the constitutional amendment giving constitutional status to the OBC Commission, it was no longer open to states to tell us who are OBCs. This function can be performed only by the center. This has resulted in excessive centralization of the power to identify backward classes, a power which was hitherto available to all the states. And I think we should be thinking of that issue also very seriously. Now, let me come back to the notification of 7th May 2021. What was the impact of this notification? In my opinion, in effect, it reserves posts at the promotional level for SC and ST and makes them available to the open category in order of seniority. Seniority, as I said, being determined not by the date of entry into the cadre, but by the date of entry into the service. By one stroke of a pen, two constitutional amendments were done away with. The 77th Amendment, which added Article 16(4)(a), granting to SCs and STs the right to reservation and promotions, and the 85th Amendment, granting to scheduled castes and scheduled tribes consequential seniority when promoted. By one single stroke of a pen, the position as it obtained in the 1995 Indira judgment was restored, and the constitutional right to reservation and promotion through consequential seniority was invalidated. You see how easy it is to undo a constitutional amendment. This particular government resolution was not even placed before the cabinet. It does not have the imprimatur of the cabinet on it. It's just a GR signed by an undersecretary. Now let's go back to the genesis of the dispute. It was in 2018 that the state of Maharashtra decided, the High Court of Maharashtra decided in the Vijay Ghogre case that the state of Maharashtra had not complied with the Nagaraj conditionalities and hence struck down reservations. Significantly, the statute, the law under which these reservations were made was not struck down. So this brings us round and round and round and round and back to the Nagaraj conditionalities, which are what? Which are that there should be data for their backwardness, that there should be inadequacy of representation at promotional levels, that there should be data to show that these promotions had no impact on efficiency in administration. This judgment was appealed in the Supreme Court of India by the state of Maharashtra, which vigorously supported reservations and promotions. During the pendency of the appeal, the general judgment was decided, holding that it was not necessary to produce data for backwardness for SC and ST. And let me tell you, because by definition, SC and ST were backward. Let me tell you, I had appeared in the Jarnial case, and even if I may say so myself, I was largely responsible for ensuring that this particular conditionality was removed. Now, whereas a lot of people argued that the state could not, that the court could not decide on whether they were backward or not, because Article 340 of the Constitution of India mandated that only the president could decide whether a particular community deserved to be in the backward classes. I chose to put my argument on a higher level. And my argument was that when the president puts a scheduled caste community in the presidential order under Article 340, they do so on the ground that these communities have been hitherto considered as untouchable. So I think besides talking about backwardness, it was very important for me to talk about untouchability. And it was important to tell the court, I can't even begin to tell you how the bias of judges reflects in open court in the exchange between lawyer and judge. And as Dr. Mohan Gopal pointed out, one such bias is reflected in the Jarnial judgment when the court says at higher levels, you don't need to promote SC and ST. And it was at that point that I turned around and told the judge, for your information, the President of India, who happens to be a scheduled caste person, was not permitted to enter the Puri temple. There was pin drop silence in the courtroom because the fact could not be disputed. What answer would you give to something like that? And so I persisted in saying that the president does put in the schedule castes which were formerly considered untouchable, and ultimately the court did hold that there was no need to prove backwardness. We are then left by the so-called two other conditionalities. I have come to the conclusion that no matter what the SC and ST community does, they will never be able to comply with so-called conditionalities. Newer and newer conditionalities will be invented. It, of course, shocked my conscience that the state of Maharashtra, which had consistently defended reservations in promotion in the Supreme Court of India in front of my very eyes, where reservation has been in existence in promotion since the year 1974, suddenly turned around in the year 2001 and scrap all reservations and promotions. How does this happen? In my opinion, it is because we have a very unclear understanding of what we mean by the constitutional right to equality under Article 14. In line with the fact that there is no clear understanding in the court, we also don't have a clear understanding of what is meant by Article 15, which mandates non-discrimination based on sex, race, and caste, or any of these uh, markers. And this is what finally leads us to a collapse in Article 16 of the Constitution, 16.1, where there is no understanding of what exactly is meant by equality of opportunity in public employment. So, over the years, as we all know, there's been a systematic attempt to reduce our understanding of equality, of formal equality. This understanding would mean that a person belonging to scheduled caste and tribe and the upper caste are equal in terms of their opportunity in public amount of employment. This, in my opinion, amounts to making equality stand on its head. I believe that society functions through its networks, which are closed and do not permit entry by outsiders. These networks are based on the triple combination of caste, class, and sex. These networks are, so to say, genetically inherited. This is what accounts for dynasties in all our major institutions that we see in society. It operates within the legal profession, it operates in all professions, it operates in politics. I know of cases where litigation itself has been inherited by 5 generations of lawyers, all belonging to the upper caste. Where position, power, education, employment, and landed property all contribute to the availability of opportunity, I fail to understand how we can say that we have equality of opportunity in this country. If this be the position, then on what basis can we say that an upper caste person and a scheduled caste person must equally compete for a place in public employment? Now, the Constitution has its own solutions with full knowledge of the existence of these networks. Our Constitution makers drafted 14, 15, and 16 as a trinity of equality. And we need to read them together to understand the issue of equality better. Article 15 tells us that wherever there is discrimination, there can be no equality. That's how I read Article 15. Discrimination is the act of and the outcome of overt acts which push back a person from exercising all human faculties. Dr. Mohan Gopal read out a portion from the judgment in Jarnial, which is based on pure and simple bias. Bias, which is an aspect of discrimination. Discrimination itself is a barrier to self-development and progress in the real world, as also in matters of public employment. And that is why I think Dr. Mohan Gopal reminded us so beautifully about what Mr. Nagappa said, that this is not a claim that we are making out of, asking for charity. It's not a claim to development. It is a claim to have our claims recognized. And this is what we need to understand. What are our claims on this nation? What exactly is the claim that we are making on this nation? So, as I said, discrimination is only the overt act by which our claims are being denied to us. And all that we are asking for is lift this barrier of discrimination, and we will then know how to take care of ourselves. Discrimination can only be undone by actively ending discriminatory practices. And one of the most obnoxious of discriminatory practices has been the practice of untouchability, which I said is the basis on which castes are included in the list. Historical discrimination, which is in some small measure was sought to be undone by the institutional device of reservation in 1604. India is unique in the world in providing for reservation in matters of public employment in its constitution for backward classes. No other country in the world has such a provision in its constitution. Rwanda does have a provision in its constitution making 50% reservation for elected representatives to be women. And thanks to it has proved that to be a measure where you will find in Rwanda more than 50% of elected representatives are women. No other country in the world, again, has the number of women in the political space as in Rwanda. We need to distinguish between reservation and affirmative action. It is not affirmative action. As one of the judgments in the Supreme Court tells us, it is like standing in a separate queue from the unreserved category. And there is no way that a person from the unreserved category can join the queue of the reserved category. Now let me move to the issue of adequate representation. How does this enter the picture? As Dr. Mohan Gopal pointed out, it is a standalone right which we find in Article 16.4. Controversies I would like to draw your attention. It is my submission that we should not be called upon to provide adequate data for adequate representation at all. And the second conditionality in Nagraj should also be done away with. And my reasons are as follows. We know that as far back as 1995, we had a decision of the Supreme Court in Sabharwal versus State of Punjab. It held that reservations are to the post. This meant that in a 100-point roster, relevant posts will be reserved in accordance with the percentage fixed for SC and ST. Once that is done, the controversy of adequacy of representation would become irrelevant. All that we would have done is to ensure that the roster is properly maintained. Therefore, in my opinion, the second conditionality of Nagraj is a hoax. It's a smokescreen to prevent us from realizing the right to representation. Forget for a moment the word adequate. Let's say it's a right to representation, and we will come to what it means when we use the word adequate in addition to the word representation. But let me quickly come back to equality. I'll move a little faster because I know there are many speakers today. We all know that in state of Kerala versus Thomas, the court held that 16.4 is not a proviso or an exception to 16.1, and by definition, therefore, it ties in very neatly with Article 14 and 15 as well. This position was reiterated in the Indira Soni case, where the court held, and I quote, but that is only an emphatic way of stating the principle inherent in the main provision itself. In our respectful opinion, the view taken by the majority in Thomas is the correct one. We too believe that 16.1 does permit reasonable classification for ensuring attainment of equality of opportunity assured by it. All the same, legislative anxiety of affirmative action by preferential treatment to a disadvantaged group lagging behind may not be doubted. Differences between reservation and preferential treatment is that in one group or class or collectivity is separately provided for and the competition is among them only, whereas in preferential treatment, the collectivity is part of the same group, but it is permitted some weightage due to social, economic, and any other justifiable reason. For purposes of achieving equality by result, Article 16 creates two compartments, one general and the other reserved, and that both are paired together. But preference is available in the same compartment. Validity of one depends on the constitutional sanction, whereas the second has to stand the test of reasonableness. For instance, the reservation of backward classes cannot be assailed as being violative of the constitutional guarantee, whereas preferential treatment can be upheld only if it is reasonable with nexus it seeks to achieve. Article 16, unlike Article 14, is a positive right to equal opportunity. Therefore, any preferential treatment shall have to be tested in the light of the constitutional objective of the articles which it seeks to achieve. That is what its nature, operation, and effect is. Reservation made for backward classes of citizens achieve the constitutional goal of achieving equality of opportunity for all. Same cannot be said for others. Any reservation for any other class could be, as already explained, contrary to the constitutional objective, thus invalid. Wards of military personnel, political staffers, etc., can be extended the benefit of Bennigan discrimination, as they would be cannot be extended as they would be violative of equality of opportunity. Now, this passage in my mind should put to rest for all times to come our understanding of equality, but unfortunately, it has not been so. And incidentally, in the Nagraj case, the running thread of reasonableness, which has to be shown for preferential treatment, was applied to reservations. I hope I'm clear. If I'm not clear, I would like to explain that proposition. The running thread of reasonableness, which is required to be shown in the case of preferential treatment, was applied when it should not have been applied to reservations in employment, which is a constitutional right. You cannot apply the test of reasonableness to a constitutional provision. Now, despite this, you will find that this position of law is not accepted by the Supreme Court repeatedly when it comes to the question of reservations and promotion. However, I had the privilege of arguing the case in Pavitra 2, where we cited the M.N. Thoman case, and it is to our good fortune that the Supreme Court accepted this proposition and held that Thomas' case had properly understood what was meant by equality. And the court said social justice is concerned with distribution of benefits and burdens. The Reservation Act of 2018 of Karnataka, in providing consequential seniority, furthers the vision of substantive equality and is valid. Now, this is the other confusion you'll find in judgments of the court. They're unable to distinguish between what they call affirmative action, a concept borrowed from the US Constitution and its jurisprudence, and reservations. And the court says, while affirmative action may be permissible under 15.4, while dealing with 16.4, there are constitutional obligations in place. Interesting quote from there, I'll read it. Clause 4 of Article 16 contains an enabling provision. Mind you, I have a quarrel with the word enabling. Enabling. Please note, please all of you make a note, the word enabling does not occur in Article 16. It's nowhere mentioned in Article 16. And yet it recurs constantly in every judgment of the court. Clause 4 of Article 16 contains an enabling provision to empower the state to make reservations in appointments or posts in favor of any backward class of citizens, which in the opinion of the state is not adequately represented in the services. Clause 4A contains an enabling provision, which, mind you, the court is overlooking the word shall in 4A. Provisions which allow the state to provide for reservations and promotions with consequential seniority in posts or classes of posts and services under the state in favor of SC and ST. Clause 4A also uses the expression which in the opinion of the state are not adequately represented in the service under the state. Now, after that, we have a long discussion in Nagraj, in Pavitra 2, which in the interest of brevity, I will skip over. But the court reiterates at para 113, the first principle is that executive arm of the state is aware of the prevailing conditions in the state. What does this mean? It means that before making a reservation, the state knows that in my state, what is the representation of SC and ST in the promotional level. And then the court says this is the privilege of the legislature. Now, let me come to the issue of representation itself. And although Dr. Mohan Gopal, in his opening comments, said the issue is not representation, the issue is my claim. But in my opinion, these two issues are inextricably linked with each other. Let's give it a closer look. The critical part of Article 14, namely reservations for those in the opinion of the state are not adequately represented in the matter of public employment, 16.4 creates what Dr. Gopal has described as a fundamental right to adequate representation. For a moment, I do not wish to emphasize the word adequate. I'll come back to it in a minute. Ingenious lawyers and judges have turned this proposition on its head, and far from making it a right, have reduced it to a barrier to reservations. So we need clarity that over and above the right to representation, there is a right to adequate representation of SC and ST in public employment. Once the right to representation is seen as a right and not a limitation on equality, the question then becomes, what do we mean by the word adequate? Moreover, these provisions no longer remain quote unquote enabling, but enter the realm of rights. I really don't know where the word enabling has come from. As I told you, it's not in 16.4. And as a practicing lawyer, it's my duty to evolve remedies. And therefore, I say that once we enter the realm of rights, a mandamus can at any time follow for the realization of our right or for the removal of barriers to our rights. And so we now come back to the expression adequate. It is here that we have to assert loudly, if at all we wish to succeed, that adequacy can be judged by the percentage of the people in the population. And this is why, from time immemorial, the central government has always given 15% reservation to SC and 8% or 9% to ST, depending on the ST population. Certain states give more than this for tribals because they have a larger tribal population. As we saw, Jernial does not accept this proposition without really explaining why this proposition is not accepted. But if we want to come out with a strategy for challenging Nagraj on the other two conditionalities, we need clear answers to these concepts. Concept of adequacy needs to be understood clearly, and the nature of the right. So I would say representation is a goal in itself. Adequacy of representation is a constitutional goal in and of itself. And I'm once again reminded about the passage that Dr. Gopal read out from Mr. Nagappa, where he said, don't take our ignorance or our deafness or our dumbness for granted. A claim is a claim. And therefore, that claim that we wish to have our fair share in public employment and in all organs of governance will remain a claim which has to be articulated in a court of law. And so, if we were to come back to the 40-point roster or the 100-point roster, in my opinion, after Sabharwal, there can be absolutely no controversy over the question where the court said reservation is to posts and not to vacancies. There can never be any question of any overrepresentation, which I suppose is the bugbear of the open category. When they question and ask for data on adequacy of representation, what they're really saying is, look, aren't you people already overrepresented? That's why you want data on adequacy. The state has simply to show that they have a roster, which they maintain, in which certain posts are filled up for reserved and unreserved category in accordance with the percentages fixed under their laws, rules, and regulations. On the other hand, questions of underrepresentation may arise when a post in a reserved category is not filled up on the ground of non-availability of suitable candidates, and there is a carry forward on the roster. So if at all these questions arise, they will be questions of underrepresentation and not over-representation, where different kind of remedies will be called into question. Similarly, the question over representation would not arise, and the second conditionality in Nagaraj will have to be thrown out of the window. Then, of course, you reach the third conditionality, that is of efficiency in administration. I can do no better than read out from Pavitra, where it was clearly articulated. And I read para 152, the Constitution does not define what the framers meant by the phrase efficiency of administration. Here it is. These phrases are not defined in the Constitution, and over the years, upper caste judges have put meaning into them, upper caste lawyers have put meaning into them to suit partisan aims. Article 335 cannot be construed on the basis of a stereotypical assumption that roster point promotees drawn from SC and ST are not efficient, or that efficiency is reduced by appointing them. This is stereotypical because you see the word stereotypical refers to discrimination and bias. What is a stereotype? A stereotype is a biased opinion about a particular person because it makes deep-rooted social prejudice. The benchmark for the efficiency of administration is not some disembodied abstract ideal measured by the performance of a qualified open category candidate. Efficiency of administration in the affairs of the union or of the state must be defined in an inclusive sense where diverse segments of society find representation as a true aspiration of governance by and for the people. If, as we hold, the Constitution mandates realization of substantive equality in the engagement of fundamental rights with the directive principles, inclusion together with the recognition of plurality and diversity of the nation constitute a valid constitutional basis for defining efficiency. Our benchmarks will define our outcomes. If this benchmark of efficiency is grounded in exclusion, it will produce a pattern of governance which is skewed against the marginalized. If this benchmark of efficiency, just pause here for a moment. What then is the benchmark of efficiency? The benchmark of efficiency would be whether you have given proper governance to the marginalized sections of society. So when governments do their study on efficiency, what are they supposed to show to the court? They're supposed to show to the court that our Ministry of Social Welfare was able to do A, B, C, D, E. Our Ministry of Power was able to do A, B, C, D, E. And this is where, when you have scheduled caste and scheduled tribe people employed in these positions, the ordinary person feels a sense of identity, a sense of connectedness, a sense that I have somewhere to go with my grievance. And as you know, all ministries are now supposed to put grievance procedures in place. But if the grievance procedure goes to a monster who is biased, what is the purpose of that grievance procedure? So the court continues, otherwise, our past will haunt the inability of our society to move away from being deeply unequal to one which is founded on liberty and fraternity. Hence, while interpreting Article 335, it is necessary to liberate the concept of efficiency from a one-sided approach which ignores the need for and the positive effects of the inclusion of diverse segments of society on the efficiency of administration, the union and the state, establishing the position of the SC and ST as worthy participants in affairs of governance is intrinsic to an equal citizenship. Pause here. Therefore, our right to adequate representation is our right to equal citizenship. Equal citizenship recognizes governance which is inclusive, but also ensures that segments of our society which have suffered a history of prejudice, discrimination, and oppression have a real voice in governance. Since inclusion is inseparable from a well-governed society, there is, in our view, no antithesis between maintaining the efficiency of the administration and considering the claims of SC and ST to appointments of service and posts in connection with the affairs of the... I would imagine that with this judgment, the third conditionality of Nagraj also gets destroyed. The court, of course, goes on to quote Amartya Sen. I will not bore you with those quotations right now. They're readily available in the judgment, and I would urge you to take that judgment seriously. And then we come to what? Now, my question is, as I conclude, and yet, despite this constitutional outcome in Pavitra 2, we find no mention of the judgment of Pavitra 2 in the subsequent judgment of Manoj Kumar. This not only goes counter to the law of precedent binding on coordinate benches, but it points to a more fundamental question. What, after all, is the meaning of equality of opportunity? Have our judges understood it? I repeat, it is obvious there is no understanding of this question in the Supreme Court of India. Moreover, constitutional adjudication cannot be determined on words such as enabling, words in any event which have been coined by the Supreme Court of India, on which to hang decades of decision making by the courts. I need to sound a word of alarm over here. My colleagues at the bar, who traditionally represent non-reserved categories and often drown out my voice, always argue now that equality and reasonableness are part of the basic features of the Constitution post Nagraj. I have heard the lawyer who argued the Nagraj case. He appeared against me in Pavitra, and this was his main argument. His main argument was equality and reasonableness are now part of the basic features of the Constitution. It was like holding out a threat to the judges that since Nagraj has held that these are the conditionalities, you cannot do anything otherwise. Now, in the past, we have been told that we are violating the right to equality of the unreserved category. In future, we will be told that we are acting contrary to the basic features of the Constitution. And therefore, I conclude by pointing to the dangers ahead. As a lawyer practicing in this field of work on behalf of the reserved categories, I already told you how my voice was drowned out before the High Court while challenging the GR of 7th May 2021. I would say that we are faced by a primordial challenge of bias, of stigma, and of the ever-present practice of untouchability and of atrocities. I was speaking to my colleagues who appeared with me in the High Court of Bombay, and they all agreed that the existence of atrocities is a very real marker. And we were both discussing this, that we should tell the court, why don't you add to your list the collection of data on atrocities against scheduled castes and scheduled tribes before you accept any argument that there should be no reservation in employment and in promotions for scheduled castes and scheduled tribe, and use that as a benchmark to decide whether there has been equality of opportunity. Thank you for your patience. I'd like to stop here and would be delighted to listen to the others and get feedback.
Thank you very much, Madam Indira Jaising, for a really wonderful, masterful survey of the crisis facing the law on jurisprudence, that it is actually being attacked and hijacked and sabotaged in our country. And I think your intervention will help all of us realize what the correct position is on law I'm very much in favor of adequate representation as a fundamental right, but actually adequate representation is typically something that is assured by the governing class to those who are not represented. But the irony is 85% of India is forced to ask for adequate representation from the 15%. So so I think we both agree that adequate representation is important for the majority and for the minority. But what Mr. Nagappa was reminding us was that we are, as he said, the aboriginal people of this country, and it is what we want is our claim and our rights, and this is not any favor to us. This is what is due to us as 85% of India. So thank you very much for reinforcing all those points brilliantly. May I now request Dr.K.S. Chauhan, please, to kindly address. I will just unmute and Mr. Chauhan here. Not able to find him. Yes, sir. I found him, sir. Yes, request. Dr. Chauhan, warm welcome to you.
Yes, sir. Thank you, sir.
Another formidable warrior. And it was Madam Indira Jaising who strongly suggested to us that we should request you to be on this panel. So I'd like to thank her also for that, and thank you for coming on and presenting. Thank you. Welcome, Dr. Chauhan.
Because of her assistance in this subject, at least 50% of problem we have sorted out. But and even if you argue, then
Dr. Chauhan,
courts are
could
not
I interrupt briefly?
Yes,
Dr. Chauhan, could I interrupt? Could I interrupt very briefly? Your face is not fully seen. I think if you can slightly adjust the camera. Dr. Chauhan, your face is not fully visible.
Now all right, sir?
If you can slightly adjust the camera.
Now I think all right, sir.
That your face is not fully visible. If you can move the camera slightly.
I have moved, sir. I think it should come.
Yes, perfect. Thank you, sir.
Sir.
Now, yes, now I can hear you, sir. I think the bandwidth is a little weak at your side here.
Hello.
Yes, sir. I think the bandwidth is a bit low, sir. I think you're on your mobile.
Right. But at my place, it is visible clearly, sir. So instead of photograph,
yeah,
just
now we can see, sir. But I think because you're on your mobile, the image, voice and image are breaking up.
I think it should.
Yeah, yes, sir. But I think the problem is that the bandwidth on your mobile.
Sir?
The bandwidth on your mobile is not enough, so we are not. So it's breaking up. The voice is breaking up. Image and voice are both breaking up.
Right, sir. In your thing is surfing up, but mine is, I think, all right.
No, sir. It's yeah, I can see that it is a little bit. It is rebooting. It's reloading all the time.
Right, right. Sir.
Why don't you
So
carry on?
that may be some technical problem, sir.
Yes, sir. Maybe you can turn off the camera for a little while and just only have the voice, sir. It may be better.
Or right, I would stop video.
Yes, sir.
Sir,
Yes, sir.
in fact,
Yes, sir.
the issue which we are facing, yeah, file 16.4 or 16.4a, these are fundamental rights, or these are constitutional classification. These are decided by the constitution itself. And in P. Devadasan, there was a judgment in 1964. Justice K. Subbarao, as he then was, he gave a dissenting judgment, and which was approved in this N.M. Thomas case, State of Kerala versus N.M. Thomas in 75-76. And in that judgment, it was the view was taken that this is a constitutional classification, and it can't be said that it is enabling provision or exception. But when the Mandal recommendations were accepted by the government, after that Mandal's recommendation, when these were accepted, at that time the court has referred it to a larger bench, to a 9-judges bench. And initially the court was of the view that this reservation for backward classes is unconstitutional. But at the 9-judge bench, when they were to upset this Thomas case, they did not upset that case, and the constitutional classification principle was upheld by the Supreme Court. And because of that, now it become a express provision and a constitutional classification itself. So if it is a constitutional classification, then you cannot say that there will be limitations on that right, because those limitations, those were not available when this was exception. But our jurisprudence, our system, they have evolved in such a way that the limitations they are talk of in Indira Sani case. And in Indira Sani case, the majority judgment on this point was of 6 judges. First, the major judgment was by Justice Jeevan Reddy, and he has said in question 2A of Indira Sani that this is a constitutional classification. And this Jeevan Reddy judgment, he has taken a view that this is a constitutional classification, and this view was affirmed by 2 judges, Justice Sawant and Justice Pandian. Justice Sawant and Justice Pandian, and the 4 judges were with Justice Jeevan Reddy. So 6 judges have affirmed that view. And the dissenting view was of Justice T.K. Thoman from your state. He was a dissenting judge in para 284 of dissenting judgment. He had said that this is a enabling provision and this is a discretion. So this was his view, which was approved by the 2 dissenting judges, Justice R.M. Sahai and Justice Kuldeep Singh. So this was 6-3. So the problem is that if this is a constitutional classification or a fundamental right, if that is the case, then we have a right to claim this. But in Nagaraj, the court has taken a view that this is an enabling provision and a discretionary remedy. So thereafter, the UP judgment, because Mayawati has intentionally, she was against reservation, she was trying that reservation promotion should not be followed in UP. So she has put up the advocates of a nature who were against reservation for defending reservation. And that is the reason that in UP, for the first time, the case was decided in a way that throughout the country the reservation was affected thereafter, and one by one all states after 2012 said no reservation because it is our discretion. So the basic issue is that the backward classes and scheduled caste and scheduled tribe, they are similarly placed, and their condition are also similar. So far as their representation is concerned, that is also similar, because they are not adequately represented, and the scheduled caste, scheduled tribe also not adequately represented. And because the Brahminical forces, they are occupying all these slots, so they evolve one or the other criteria, so that the reservation should be scuttled down, and the reservation for OBC is not there. That's why they say that in this remaining portion, OBC and general, OBC and unreserved category, they are all unreserved category for that purpose. So in my view, till the constitution is amended and the reservation for OBC is specifically provided, or this Indira Sani judgment is reviewed, because to that extent I feel, even if there would have been no amendment, this is a restrictive interpretation of Article 16.4, because post and appointment, the word which is used in Article 16, that does not that does not say that you will not give a representation to them. So there should be representation to all kind of people, and the representation is essential, because in democracy every section of the society should be represented. So for OBC, I feel there should be reservation in promotion. That is one facet. Then the second facet is that Article 16.4, 16.4a, 16.4b has to be read with Article 17, like Madam Indira Jaising has said, because the scheduled caste and scheduled tribe, they are facing large scale untouchability, and discrimination is there. They are facing everyday untouchability offenses, atrocities. So if they are facing, then you cannot equalize them. There have been examples where the scheduled caste who are highly placed, they have been discriminated, like the man who is occupying the position of president of India. He was not allowed to enter in a temple in Rajasthan, and the same president goes to Odisha. His wife was thus pushed, and there is both places the criminal cases are going on. If a person who rose up to the level of president of India, even he could not get the dignity, how you can think that the dignity by just enjoying reservation, by getting one promotion or two promotion, you will get dignity and there will be no discrimination. So this will be a double-edged sword for the scheduled caste and scheduled tribe and backward classes, because they need representation at all levels. If they are not represented at all levels, then the real democracy can't come. Secondly, Justice Pandian, in his judgment in Indira Sani, has specifically said that this power coupled with duty principle would be applicable. Power coupled with duty principle means that this reservation is forcible. You can enforce this reservation. So Justice Pandian was part of the majority judgment. So if you are to apply the minority judgment, you have to refer it to larger bench. In the UP cases, as I was saying, after the first phase of the judgment, UP Power Corporation, in the second phase, some employees, they came to us, then we drafted the petition, and I said for the first time that this Nagaraj is constitutionally incorrect. Justice Deepak Misra said, no, we are not going to reopen it. 9 years have gone by, and you tell what we can reform in this. Whatever we can reform, only that you talk. You think that we will refer it to larger bench. We are not going to refer it to larger bench. And afterwards, in Himachal Pradesh, the Supreme Court has given direction for implementation of reservation promotion. And when it comes to the contempt petition, the Himachal Pradesh government has engaged Dr. Rajiv Dhawan, who is the main arguing counsel of anti-reservationist, saying that this is the power of the state government, and the state government has decided that we will not give reservation. And at that time, Congress was ruling in Himachal Pradesh. Thereafter, this Uttarakhand case. In Uttarakhand case, the data was available. Time Congress appointed one committee headed by a former chief secretary with one vice chancellor, one principal secretary of the government, three-member committee. They were appointed. They collected data, and 19% and 4% was the representation to be given, and the data was nowhere more than 10% in class 1, class 2, class 3, class 4. All positions the data was less. Likewise in Bihar, in 2011 they hold this data exercise, and the representation was much less. So the government which was ruling, Nitish Kumar was ruling, they appointed committee. The committee carried its exercise. They enforced that provision. The High Court 4 times decided that you can't enforce it because you are not complied the data. So the problem is not that the data is there or data is not there, because in Madhya Pradesh data is there, in Uttarakhand data is there, and in Bihar to them, and boards are not allowing the constitutional provision or statutory provision to operate, because the reservation because this reservation is available in all states. All states means all developed countries. And when this Nagaraj was argued, it was decided by the US Supreme Court permitting reservation in promotion. Chief Justice Sabharwal, who was presiding over, was not inclined to give us person will argue that side, and we were not form part of those 6.
Sir, you may want to video को बंद कीजिए sir. Sir, video, sir, your voice is not coming, sir. Please, video, you may stop the video. Voice is not coming. Voice is not coming. Yes, yes, sir.
So the main problem is that in US they follow this type of reservation, and in their constitution there is no provision like in our constitution. Even in their statute they don't have a specific provision providing for reservation or affirmative action. Only the equal protection, which is the word which has been interpreted by them, and because of that equal protection, they are giving all reservation at every level, even in the management, even in the corporate appointments and all those things. And in India, it is part of the constitutional scheme, but we are not getting it. Now the question is that the majority judgment in Indira Sani, whether this can be applied by Nagaraj or Jarnail Singh, which are 5 judges bench, and Indira Sani is a 9 judge bench. So if Indira Sani is by 9 judges bench, it can be reviewed only by the 11 judges bench. Till the 11 judges bench say that this part of the judgment is constitutionally incorrect and we overrule, that judgment they cannot review it. They have to apply that principle. We are trying because this adequacy principle, adequacy is part of the constitutional scheme. But if it is a fundamental right, then we have right to challenge it before court. Now they say that we do not have right to go in writ petition. The mandamus is not available to us. And the whole problem is that the basic issues which we are raising, the court is not answering those issues. And there are some reasons which I can't expressly say in this webinar, because I know so many things which I can't expressly say, because the other system will operate if I will say all those things. That's why I don't want to say all those things. Now there is a request for this reservation by Jats, Gujars, Patels, and Marathas. They are particularly dominant ruling caste, but they are also Sudras. If they are also Sudras, when it is suiting the Brahminical forces, they say that they are equal. But as soon as their part is satisfied, then they again say that you are Sudras, and they discriminate against them. So that's why I feel that the whole process which we are facing will be sorted out only if the constitutional principles which are expressly given in the constitution. It is a surprising situation where nobody is reading the constitutional provision. If we say that, my lord, read article 16(4)(a), then the judge will say, no, we know all that, but you just argue. So they are reading their own judgment like a statute. Their own judgment like a statute, they can't read it. And the principle of say adequacy, even if it is applicable in state of this R.K. Sabharwal versus state of Punjab, 1995 Supreme Court has said that post-based reservation should be applicable, because vacancy-based reservation is giving advantage to the reserved category. And because of this, the post-based roster has been applied. But that principle could be useful if they follow the backlog vacancies. Whatever backlog is there, they should give backlog to the SC, ST and OBC, but they are not giving that backlog. So what is the use of this post-based roster? Because post-based roster means that you have to give them backlog vacancies. Whatever you are not filling up today, tomorrow if candidate is available, it should be filled up by that candidate. And they are not giving that representation. That's why I feel that the vacancy-based roster should be restored. And this Article 16(4)(a), this is a constitutional mandate, the constitutional obligation under the scheme of the Constitution. And I feel this judgment in Mukesh Kumar versus state of Uttarakhand, or this Uttar Pradesh case, Suresh Chand Gautam versus state of UP, and Nagaraj case, they have to be referred to the larger bench, because this principle has to be settled by the Supreme Court. Till the Supreme Court settled this principle, we can't get justice, and everywhere the reserved categories, the members of the scheduled caste and scheduled tribe, they are not getting representation because of the court interference. And this 50% ceiling which they have put by Article 16(4)(b) Constitution 81st Amendment Act 2000. Before that, this ceiling was not there in the Constitution. But despite this, they are giving the economic reservation. The economic reservation, and whenever you discuss anything, they will say the reservation should be on the basis of economic criteria. It could be on the basis of economic criteria if the discrimination is based on economic criteria. The discrimination is based on the basis of social parameters, social indignity is there. So the reservation has to be on the basis of social criteria. If the criteria is changed, the social conditions should also change, because we have to give them a platform. And if you examine it from that perspective, the representation of the scheduled caste and scheduled tribe and backward classes in the higher position is negligible. The data which we are having or any state is having is of at least 6-7 years older, and that data is of no relevance today, because those who were in the higher position, they have retired, because in higher positions people stay only for 2 years, 3 years, like that. So this consideration of data, and the consideration of data should be there, but it should be in a way that to benefit us. It should not harm our interest. And if you examine the Indira Sani case, Indira Sani case says that that this is a constitutional classification. And so far as efficiency of administration is concerned, in the railways, there was a research conducted by experts, and those experts have found that by providing reservation in promotion, the efficiency has increased in railways. And this is a expert by Delhi School of Economics and Michigan University in USA. They both conducted that research and data, and they reported that because of reservation, the efficiency has increased in that railways. So I feel that the efficiency criteria will also have to give and go by. Moreover, even if you examine from the other angle, like for scheduled caste, there are three benchmarks: good, very good, and outstanding. These benchmarks are for scheduled caste, backward class, scheduled tribe, and general or unreserved category. These benchmarks for all, and normally there is no relaxation nowadays. Though the constitution provides for relaxation, the relaxed standard is not there. Like you have, if you have lower ACR, then you will not get promoted. So if the standard is same, where is the question of not having efficiency, or the efficiency of administration will be jeopardized by the by giving reservation in promotion. So we have to examine from a right perspective, and the equality clause which is given in the constitution in article 14 to 18 has to be read as a whole, because this article 16, particularly article 16.4, 16.4a, 16.4b, and the other clauses of article 16, they are only a express classification provided by the constitution makers or the subsequent legislations. So those are also constituent amendments. So if the constitutional amendment is there, and you have approved that amendment, upheld the validity of a constitutional amendment, thereafter you cannot go and see that this is the judgment of the Supreme Court. So we will see the judgment of the Supreme Court, and we will not read the provision of the constitution. And moreover, in the state of Madhya Pradesh, Bihar, and Uttarakhand, they have denied reservation even from Supreme Court, because they say that the present BJP government has said that we don't, this is our discretion. We are not willing to give reservation. Earlier, the Congress government has also taken the same stand. So we have to understand from both angles. Congress and BJP, they are both Brahminical party, and the leadership in them, they do not want that the socially marginalized section people, they should rise in the ladders. And that's why during the 2014 elections, the General Secretary of the Congress party, that Janardhan Dwivedi, in the mid of the election, he said that there should be no reservation in promotion, and reservation should be restructured. So it means they are not in favor of SC/ST voting for the Congress, because they, when during election, when you are saying this, it means that the mindset of these people are of a different nature. And I feel that we have to understand this. Like in Rohtas Bhankad versus Union of India, there was a case by 5 judges of the Supreme Court, but we are referring it to the different benches. But even that case doesn't get noticed. Like B.K. Pavitra, this Rohtas Bhankad was decided in 2014. Initially, when it started, the bench was against, but Justice Chalmeswar, he was part of the bench. Then he explained to the Chief Justice R.M. Lodha, and thereafter, then they changed their mind, and finally the judgment came in our favor. So, if a judgment come from 5 judges in our favor, even they don't want to see that judgment, because the judiciary is not effectively represented. And even if we get an opportunity, we are also behaving in the same fashion. So secondly, after 1981 census, there has been no increase in the reservation percentage. After 1981 census, 91 census, 2001 census, and 2011 census, 30 years have passed, and there is no change in the representation of the scheduled caste and scheduled tribe and backward classes, because the reservation which was available at that time, it is still existing. So their population has increased, and at least 5% should be added to the existing 5 or 6% to the existing reservation percentage. And the migrated scheduled caste and migrated scheduled tribe, all those criteria are applied, because if you suppose you are from Haryana and you settled in Noida, then you will not be treated as a scheduled caste. If you are from Uttar Pradesh, you settled in a Gurgaon, so you will not be treated as a scheduled caste. So the population percentage is also decreasing because of all these concepts, and these concepts are artificial concepts just to deny representation to the members of the scheduled caste and scheduled tribe. And I feel that the only thing which will change the situation is that we should demand that there should be reservation in promotion for backward classes, because the whole system will change only afterwards. Because if you see, before the implementation of Mandal, the same way we were not getting the direct recruitment appointments effectively in states, but thereafter the problem is not there to that extent. So the whole issue which we have to examine is that what is the constitutional principles on which the court should decide it. Constitutionally, Nagraj and Jarnail Singh even, because Jarnail Singh just say that social backwardness criteria will not apply, but at the same time has decided in a way that the creamy layer principle will be applied. So creamy layer and social backwardness are the same thing, because in Mandal they have understood it as a same principle. But because in Mandal, when they say that this is a social backwardness criteria and it will not be applied to scheduled caste and scheduled tribe. When I argued this in Suresh Chand Gautam, and then subsequently Madam also supported in this Madhya Pradesh and Bihar and other cases, and because of her active support, these were referred to a constitution bench. So I am grateful to Madam for her support in this subject. Otherwise, perhaps we were just arguing, and even these issues would not have been noticed by the court. Secondly, I feel the requirement of data is not the requirement under the constitutional scheme, because if you apply the classification principle, then the constitutional right is evolved, and if you apply the constitutional right, then in that case the requirement of data efficiency, that will automatically go. That's why we are trying that the this Nagraj judgment should be again referred to a larger bench, and till that is referred to larger bench and it is decided by a larger bench, this problem will not be sorted out. Because in Maharashtra, in Chhattisgarh, and other states like Bihar, in these states, the data is much less. And in spite of having lesser data, the states like Maharashtra is still ruled by a Congress, is also a lie in that Chhattisgarh is fully ruled by Congress, and this Bihar is by Nitish and BJP. So in the last 2-3 weeks, they have decided, or they are saying that we will promote only the unreserved category candidates. And the same thing like when this Uttarakhand was ruled by the Congress. Congress has done the same thing in Uttarakhand and have not given this reservation in promotion to the Uttarakhand, and thereafter the whole game was recycled. And I feel till the whole principle is strike out, the principle which we require to be reinstated will not be effectively changed. And we have to understand it in a constitutional principle, in a constitutional manner, because the Nagraj judgment is by 5 judges and Indira Sani is by 9 judges. Whatever is settled by the Indira Sani, and the constitutional amendment has not taken place on that aspect, that aspect will be binding on the court. And that is the reason that this Jarnail Singh has said that in para 36 of Jarnail Singh, that the social backwardness criteria will not apply, but we are not referring to the larger bench, because the other issues we have to strike only one issue to show that this Nagraj is incorrect. But the other issue, every issue you can't argue in the in first time that this is the principle which they are violating. That's why I feel that all these principles should be recasted. But again, I have a feeling that till the reservation for backward classes is there in the promotions, the problem is not going to be sorted out. That is my personal feeling. And this problem we have to understand from the positive sense. And moreover, the backward classes are not represented in the higher echelon of the services. And if in the higher position they are not there, they are also required, like in South India, in some states, like maybe in Kerala, Tamil Nadu, some representation maybe of the backward classes. But when you come to the North India and Central India, the representation of backward classes is almost negligible. And that is the reason that these principles are being invoked, and they want to apply creamy layer to the SC/ST also. What is the creamy layer to the ST/ST? When their person who could rise up to the level of President of India, and even he is facing social discrimination. So who should get the protection? If a President of India is not getting constitutional protection, and in that situation, I have a feeling that the condition of the socially and educationally during their marriage procession, they are not allowing even to the backward classes. The Chief Minister of Uttar Pradesh, when this Yogi Adityanath but when a OBC was occupying that house, even at that time it was purified. It reflects that the scheduled caste and backward class, they are so much if scheduled caste and backward.
Sir, cannot hear, sir. Sir, video band kijiye. When you are putting the video, can't hear you, sir. Sir, you may put off the video, sir. Yes, sir.
I put down, sir. So
Cannot hear.
not able to hear. Rights and constitution. Sir?
Yes, now we can hear, sir.
Right. So, sir, I have written a book recently in March, and it was released by the former Vice President, Honorable Sri Hamid Ansari. Madam was also part of the release function. So, in that, I have specifically put the issue that the reservation for backward classes should be there, and the other rights like this reservation rights also I have dealt with the specific and Indira Sani case, which is by a larger bench of 9 judges, that cannot be upset by a smaller composition of judges in 5 judges, say in Nagraj, M. Nagraj versus Union of India, which was decided in 2006, and Jarnail Singh versus Lakshmi Narayan Gupta, which was decided in 2018, because these judgments have basically dealt with that there are limitations on the rights of the scheduled caste and scheduled tribe for availing reservation in promotion. If this issue was there and it has been decided by the Indira Sani case, only the issue which was upset by the parliament is because in Indira Sani they have said there will be no reservation in promotion. So the other issues which were decided by Indira Sani, all Indira Sani was not against us. The Indira Sani was a good judgment, but because of the mindset they have decided, even Justice MD, he was part of the bench and he was with Justice Jeevan Reddy for that 4 judges. But on this aspect, he has said, I feel that there is the question relating to reservation in promotion is not there in these proceedings. So I am not deciding on this aspect. So that's why I have specially acknowledged him in my book, because he has taken a stand in the Indira Sani case that this reservation in promotion issue was not there before the court. So the basic issues which we have to debate, which we have to understand, is that the issue which is decided by a constitutional court of larger composition, that composition has to be taken care of. Like in after P.K. Pavitra, there should have been no chance of all these problems which we are facing, because in para 121 of this P.K. Pavitra, the Justice Chandrachud has referred to para 741 of this Indira Sani case, which says this is a constitutional classification. So that view he has borrowed from Indira Sani, and after that view's reinstatement, there should have been change in the court's thinking, but because the mindset of the adjudicatory authorities is also very relevant, and these issues, when we point out before the court, even these issues are not noticed by the relevant persons, relevant judges. So that is the problem which we are facing. And there is a judgment by the Supreme Court in a Gujarat cooperative matter, because the cooperative for cooperative there was a constitutional amendment, and Vipul Bhai M. Chaudhary versus Gujarat cooperative is the case decided by Justice Kurian Joseph, and he has given a wonderful principle. He has said that if the constitution or a statute has a principle, has evolved a principle, that principle should be made applicable to the by the legislature, and the legislature is bound to change, or the authority which is deciding a principle is bound to follow the constitutional or statutory principle. But in the cases of reservation, they are not following it. and it is only because of Justice Kurian Joseph that this was referred to the Constitution bench. Otherwise, perhaps it would not have been even referred to the Constitution bench. And the whole issue which we are debating is to adhere the settled principle of Indira Sani. If you want to change Indira Sani's principle, then you expressly change it in 11 judges, not by the 5 judges bench. That's why I feel that in the whole process, we have a feeling that there are two kind of remedy. The first remedy is to review Indira Sani case, and the second remedy is to amend the constitution to provide reservation in promotion for writing other backward classes, or now they have given other definition is socially and educationally backward classes by putting article 342A in the constitution. So you have to give them also reservation in promotion. If you give them reservation in promotion, then perhaps all these problems could be sorted out, because they are also not adequately represented, so they are also necessarily required to be placed in the higher positions. That is my feeling, and I feel that this efficiency and adequacy, which I have already stated, because this Sabharwal case has decided post-based would be applicable, and the post-based reservation has been applied everywhere after that. In every state, post-based reservation is applied by way of post-based roster. So if that roster is made applicable, the post not filled up from the scheduled caste, scheduled tribe, or backward classes, because the reserved post have to be filled up from them only. So the backlog must be filled up. Otherwise, there are pile up of backlog, and about 8 lakh vacancies in the center government which were unfilled. They have been scrapped after Modi has come to power, and there is no effort to fill up the backlog vacancies, which is a constitutional requirement after the enactment of Constitution 81st Amendment Act 2000. So I feel that the third alternative is to apply the Indira Sani principle, which is already in existence, because Indira Sani by 6 judges have decided that this is a constitutional classification, and if it is a constitutional classification, the constitutional classification cannot be altered by a smaller composition. So if you are not referring it to larger bench, this Indira Sani case, if you are not referring it to larger bench, in that case you have to apply the settled principle, and in that case the principle which are existing as on today, those principles must be followed by the legislature or the executive authority drafting the reservation policies, and the courts should also follow a reasonable behavior by following their larger bench judgments, because the judgment which is decided by a larger bench should be followed. If you are not following larger bench judgment, then there is a problem in the constitutional governance, and in a democracy, every section of society must be represented. So I feel that these 3 type of criteria, if we follow, then the situation would change. And with this, I think there are other speakers also, and the time is limited. So I'm concluding here, and I'm once again thankful to Professor Mohan Gopal and Madam Indira Jaising, and I'm also thankful with this, I'm grateful to each one of you for thank you.
Thank you, sir. Thank you very much for a very detailed presentation with such rich experience in court. I think, Madam, and you have given us a very detailed understanding at a very high level of the issues that are before the Supreme Court of India. So thank you very much. And we are recording this event, so we'll be putting it on YouTube. Now, I will take just a few minutes to supplement my earlier thoughts without repeating what had been discussed earlier. I will make only 2 or 3 points. The first point I want to make is to understand that what we are fighting is was very clearly articulated in the language of the Supreme Court from September last year, which I read out. That there is a clear feeling that scheduled caste, scheduled tribes, and especially most backward classes should not be allowed in the highest levels of government or policy in this country, because that we need high quality there. So you can see almost in a completely open way, there is a clear strategy. Yes, if you want to have opportunities, you have it at the lower level. We are not going to allow you to come into the higher levels. Now, for that, where do we stand now on reservation and promotion? To share one slide for time, summarizing where we are now as a result of all the law that Madam and you have kindly described. So if we put this in a summary, are you able to see the slide, sir? Are you able to see the slide? Can anyone answer?
Yes, sir.
Hello? Oh, yes, you're able to see the slide? Yes. Okay. So we can see that where we are now is that SC/ST reservation and promotions, which was in the Constitution as an unquestioned program until the Indira Sawhney case first laid out the principle that reservations, it was available to everyone, to all, well, backward classes to the extent they had it in the states, not at the central level, and to scheduled castes and scheduled tribes. Reservations were available for all appointments. And then we had Mandal Commission introduce reservations in the central government, central institutions. And so they ruled that reservations will only apply to initial appointments and not to promotions. And so the backward classes got thrown out, and they have still not been brought back. And that was one of the points that was made by Dr. Chauhan, that that has not been corrected until now, and it's almost like no one, that's not even an issue. But I think that is an issue, and we need to put that back on the table. But in response to that decision, the reservations in promotions for scheduled castes and scheduled tribes were restored by an amendment to the Constitution that inserted 16(4)(a), and so then there was to be unhindered promotion reservation for scheduled castes and scheduled tribes. What undoubtedly the group that I think has to be whose claims cannot be questioned. There is no gray area, there is no doubt. And indeed, until Nagaraj in 2006, no one would dare to question. Even the ruling classes would not dare to question SC/ST reservations at all. And so therefore, after Indira Sawhney, there was a constitutional amendment to protect SC/ST reservations for promotions without any ifs or buts or conditions. And we have seen that now there are 5 impediments that have been put into the SC/ST reservations in promotions in the last 15 years, starting from Nagaraj, and then we've heard in detail the various judgments in between. But where we are now at the end of the day is that we have SC/ST reservation promotion subject to the 50% ceiling imposed by under 16 and imposed by Indira Sawhney. The very confused position, but ultimately the decision in Pavitra 2 did not interfere with, nor the decision in Jarnail Singh, neither of them interfered with, and they basically, Pavitra too found a way to avoid speaking on it very with great strain. But the Jarnail Singh judgment was more clear and said that they uphold the Nagaraj extension of the exclusion of creamy layer to scheduled caste, scheduled tribe. So that leaves a very, very important issue, a very, very important issue. And one of these judgments said actually that the removal of creamy layer, and it's a very tragically ironical comment. It says the removal of creamy layer will make the backward classes truly backward, truly backward. It is like tomorrow, if somebody removes all the educated Indians and says, okay, this will make India truly backward. India is not backward, its people are not backward. But you see their intention from that they want to remove the creamy layer so that there is no capacity, they believe, they are wrong, but they believe that there is no capacity to resist. So effectively today, as we stand now, SC/ST reservations and promotions will have to, arguably will not have creamy layer. Third, while there is no need to produce data on backwardness, there is now a need to provide data for inadequate representation and to prove that there is no impact on administrative efficiency. I have no clue how this kind of data on no impact on administrative efficiency would be even obtained. And inadequate representation without a benchmark, as was discussed. Our benchmark actually should have been a population share. And that has been left to the states. It has been left vague and no benchmark has been put in. So the word adequate representation, which in the constitutional context was very clear, no one had any doubt that it meant in proportion to the share of population, starting from the intervention of Mr. Nagappa that I read out to you. It was very clear that the adequacy of representation in all respects should be with reference to population share, but confusion has been created. And also we strongly oppose this. It is wrong. It is not constitutionally correct, but there is a mischievous attempt to float the idea that including argued before and reflected in some judgments, that the reservation is not a fundamental right, it is a discretionary. And as Mr. Chauhan pointed out, there have been two very strong rejections of this in the dissent by Justice Subba Rao. He referred to that in the 1963 judgment, Devadasan. I will read out just the few lines to you. It's very important to reject this argument that the Justice Subba Rao, later Chief Justice of India, says the expression "nothing in this article" is a legislative device to express its intention, the legislature's intention, in a most emphatic way. In a most emphatic way, that the power conferred thereunder is not limited in any way by the main provision. So it is a most emphatic way that for the legislature to express that the power conferred to have reservations is not limited in any way by the main provision, but falls outside the main provision. It has not really carved out an exception, but has preserved a power untrammeled by other provisions of the article. So as far back in 1963, Justice Subba Rao said 16.4 is not an exception of 16.1, but it has preserved a power untrammeled by other provisions of the article. So from 1963, the Supreme Court's own former Chief Justice has said that 16.4 reservation is not discretionary. It is a fundamental right, which Dr. Ambedkar himself had said in the Constituent Assembly. Second, Justice K.K. Matthew in N.M. Thomas, one of the most respected judges of the Supreme Court, said, and I quote, Article 16.4 is not an exception to Article 16.1. It is only an emphatic way, repeating Justice Subba Rao's words, it is only an emphatic way of putting the extent to which equality of opportunity could be carried. namely even up to the point of making reservations. So both very strong statements from the Supreme Court saying that saying that the reservation is indeed a fundamental right, and it is not a discretionary or an enabling clause. Like every other clause, my right to freedom is triggered only when my freedom is attacked. My right to reservation is triggered only when there is discrimination or no adequate representation. So, like, it is a fundamental right that is automatically triggered when my right to equality of opportunity in matters of public employment is violated. So this is these are the, and then EWS is eating away. EWS is reservations entirely, exclusively and wholly for Savarnas. EWS exclusively and wholly for Savarnas. Reservation not for economically weaker sections, but for financially weaker individuals amongst the economically strongest sections. That is also eating away at our at the SC/ST reservations in promotions. Now, if you look at the SEBC position, the same tax on reservations continues, plus three more. One is there is no reservation in promotion for SEBC. They have to produce data for backwardness. And also there is a lot of infiltration from well-off Shudra, but Shudras are also Savarnas, but Shudras who did not suffer from untouchability, but the backward classes who have suffered from untouchability, who are Avarnas, who are the true beneficiaries of the scheme of reservations, are being edged out by infiltration into the OBC category. Okay, now I will in the last part I will give another overview of what I see as the issues we should focus on. Now, I think there are 4 issues that we should think about where reservations are being attacked. One is conceptual. These reservations are being presented to us as we said earlier, as a program of upliftment to uplift backward classes, socially and educationally backward, inferior people, to a higher level, to come up to the same level as the upper castes and the forward castes. I think all this terminology is highly conditioned, deliberately, mischievously, whereas although the Constitution uses the word reservation, not anticipating how it would be abused in this manner, actually what we are talking about is not reservation, but restoration. Restoration of the opportunities that was wrongfully stolen from us, wrongfully taken away through the caste system, through Chaturvarnya, through denying education, denying access to public resources, through untouchability, through unseeability, through the most brutal exclusion that humanity has ever seen. Opportunities that should have been with us have been taken away, and they have to be restored to us. So this is not reservation, it's about restoration. So I think we have to understand for ourselves that the story about a reservation has to be reframed, and that will change the consequences. What are the consequences of the story of upliftment? One is to then open up the space for economically weaker sections of upper caste, because if there are economically weaker sections of Avarnas that are, or the backward classes and SC/ST that are getting reservation, why not the economically weaker section of the upper caste? So they're able to open the door and transfer to the public responsibility the need to look after members of their own class who are financial failures. They had every social opportunity to be wealthy. They could go to school, they could get jobs, they could educate themselves. They had dignity, they had respect, they could enter restaurants, they could travel in buses, they could travel in trains, but they became financial failures. And now they're getting reservation. Well, why not help the financial failures from SEBC and SC/ST also? Why only favor the financial failures of the upper caste. So because we are framing it as an economic upliftment program, they've not only been able to say that this is a handout, it cannot last forever, it has to stop and weed out the creamy layer. They are also able to demand data of backwardness. First they call us backwardness and then ask us for proof. Give us proof. We didn't say we're backward. Mr. Nagappa said, give us our claim. Give us what is ours. He didn't say we are backward. He said, let us be backward, but give us our claim. Now the backward label is put on people and said, okay, you're backward. Now give us proof you're backward. Well, if we are not backward, why are we called backward? And then ask for proof of backwardness. So we have to change the first, very quickly, the first of four conversations we have to change is that this is not a program of affirmative action. It's not a program of reservation. It's a program of restoration of opportunities that belong to these classes, belong to the 85% of the country. Second, the program in the Constitution, the demand in the Constitution, the demand of Nagappa is for group equality. That there are groups. So the Constitution also says in Article 39 about equality of groups. You will all remember that the state shall in particular, Article 38(2), the state shall in particular strive to minimize inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only amongst individuals, but also amongst groups of people residing in different areas or engaged in different vocations. This is a program, the reservation is a program to bring about equality between groups. So how is this being countered? It is being countered by the jurisprudence that treats this entire debate as an issue of individual equality under Article 14. Article 14 has not been allowed to develop a jurisprudence on the equality on social equality. And again, it's because of the nature of the judges and the bar, the bench and the bar, that has not happened. So they're using individual equality to say that, look, some individuals who are better off have to be removed, and you can't have, and you're also saying, yes, because it's about uplifting individuals, you can't discriminate against other individuals or don't get reservation. Therefore, we must have a 50% ceiling on reservation, because this is all a competition between individuals, some who are getting a benefit and some who are not. Whereas in fact, this is a program to implement Article 38(2) to achieve equality between groups. So this is the second issue where we have to assert that our focus is on achieving equality amongst groups, amongst classes of people, as society defines us and as we are treated in this society. And that will also mean that we cannot recognize the creamy layer. We cannot accept the creamy layer exclusion, because creamy layer is about individuals in the group, and removing them from the group is actually intended to weaken that group. Third, the program of due share that Mr. Nagappa and Mr. Muniswamy Pillai spoke about on August 27, 1947, on due share and adequate representation, which has been reflected in 16.4. The principle in 16.4 and in the provisions on representation, reservation of SC/ST in parliament and legislative assemblies is adequate representation. The principle in education is advancement, that is more focused on individuals, but the others are group representation. So due share and adequate representation has been countered by a jurisprudence of efficiency and merit. And we will have another webinar on the issue of efficiency and merit, and therefore therefore I'm not going to go into it in any detail here, but suffice it. And on the concept of caste, I'll come to that very briefly at the end. But let me simply say here that actually we are dealing with two concepts of merit, one and efficiency. One is the Brahminical idea of merit, which is actually a superstitious religious idea of merit. Merit derived from an unverifiable last birth for unverifiable actions. The definition of merit is recognition of some good deed, the value created by some good deed. That is the definition of merit, which is also recognized in the Pavitra to judgment. So the Brahminical idea of merit is merit can be only derived from a last birth that is not verifiable, from deeds that nobody can verify, to be enjoyed in this birth, and then perhaps what I do in this birth is of no meaning, and we'll see what happens in the next birth. But the 85% of the country is told that you're going to suffer because of what you have done, the demerits you have acquired and the bad deeds you have done in your unverifiable last birth, in your unverifiable bad deeds in this birth. And if you obey us and obey the social order, then in your next birth, you will get a promotion. You will have reservation in promotion in the next birth, not in this birth. And so this kind of idea of merit is completely a false idea. It's a lie. It's a fake idea. It's a superstition. And we have to reject it. What the Constitution means, the Constitution uses the word merit only twice, and only once in a nearly relevant way. But actually, in this context, the Constitution doesn't use the word merit. It uses the word efficiency. And the important thing is to understand that here, the Constitution is talking about the efficiency of the institution, not efficiency of the person. So constitutional idea of merit and efficiency is a scientific idea of merit and efficiency. It is a scientific idea that that is verifiable. What deeds did you do? What value did you create? What should we recognize? And how should we ensure that that is rewarded? The backward classes and the SC/ST are the people who built up this country stone by stone, brick by brick, with their blood, sweat, and tears. If that is not in this life, in a verifiable way, in this world, and if that is not worth recognizing as merit, then I don't know what is. And if including recognition of that merit into adding value to the institutions of this society is not valued, I don't know what can be valued. And if you look at Article 38.1, you will also see that reservation is actually a part of Article 38.1's objective of creating JUST, just institutions. Article 38.1 says, the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all institutions of national life. This is the mandate of the entire state, to improve the quality of institutions. In other words, to improve institutional quality, IQ, and make them just. How? By making them just, so that justice, social, economic, and political shall inform all institutions of national life. Reservations is a means to implement 38.1, not just 14, but 38.1, to improve the quality of institutions in our country and make them just by recognizing the merit of those who have built this country brick by brick, stone by stone, with their blood, tears, and sweat. And so, therefore, we have to change this whole dialogue, and we have to understand that without the backward classes and the SC and ST, there can be no merit and no efficiency. Our focus is not on uplifting individuals. Our focus is on building institutions. And if you stop promotions of SC/ST into reservations, you are attacking the quality of institutions. You're attacking Article 38.1, because Article 38.1 says that all institutions must be just. If, like the Supreme Court envisages, you have institutions at the top that do not have scheduled castes and scheduled tribes, they will not be just institutions. They will be unjust institutions. And therefore, by blocking reservations and in promotions, let us understand that the Supreme Court is going against the principles of the Constitution. And I hope, like in ADM Jabalpur, someday they will recognize it and correct themselves. Lastly, the argument that is made is that we don't want reservations because it will divide our society permanently. It will fragment our society. This is another lie. It is the truth is that reservations are meant to transform society. And how are they meant to transform society? And again, we'll have another more detailed webinar on this. But actually, let us understand what caste is. Caste has been wrongly and mischievously defined to us simply as a system of division of labor, forcing occupation. And therefore, because now today, a K.G. Balakrishnan, who by the way was reversed, he said in Ashoka Thakur very clearly that the principle that very correctly that creamy layer is only a principle of identifying backward classes. It is not a principle of equality. And he has been reversed by Justice Nariman in Jarnail Singh explicitly that he is wrong. Actually, Justice Balakrishnan is right. Creamy layer is only a means of identifying individuals among backward classes for excluding them to weaken the backward classes. It is not a principle of equality at all. But coming back to our topic, let us understand that caste is not about our occupation, because then we can say there are no restrictions on a K.G. Balakrishnan becoming the Chief Justice of India. Caste is all over. Why are you talking about something that has no longer any relevance? But actually, that is not caste. Caste actually is a virus that corrupts our stories about ourselves. Every group, every individual, every community in the world has a story about ourselves. So Savarkar has a story that he and his ancestors came from the North Pole, carrying their holy books. Fine, that's his story. But what they do is they come here and they don't just tell their story. They come into our stories and corrupt our stories and degrade them and destroy them and make them shameful in a way that we ourselves don't have. We have left with nothing but a negative story that then affects our credibility. So I know a very young and brilliant colleague who comes from a family background where, let's say, his, I won't name the vocation, his family's vocation was to do X. But he was labeled as member of a community that does Y. And Y is something against which a lot of negativity was built up in society. As a result of this, today, that young man is not able to do X in the society because he is considered as doing only Y, and his whole community, his personality, his family is all identified with Y. A negative story has been built. So every community, they have come, caste is a virus that corrupts our stories about ourselves like a computer program. It corrupts the stories about ourselves, and it creates negative stories for some, but it creates very positive stories for others. Very positive stories. And also it creates conflicting stories so that we start to conflict with each other. These are stories where everyone has some degree of superiority and some degree of inferiority. So everyone feels a little bit superior to somebody else, and most of us are a lot inferior to others. A few people feel very superior without being seen as simply a person who does the occupation that is in that stereotype and nothing else. And I am not seen as capable of doing anything else except that. And it ignores the truth, because the truth is that I and my family have nothing to do with that stereotype, but we are trapped by that stereotype. And therefore, the last point I want to make is that we believe that through reservation, we will change these stories. We will change these stories about caste. We will take back our control over our own stories. I want to let Savarkar say his story, but he should not say my story. I should have the right to say my story. As an individual, as a member of my family, he should have that right. I should also have that right. He can't take away that right. So we must take back our right to tell our own story. We must tell it in a way that is truthful. And all those truthful stories are proud stories of struggle and contribution to the building of this country. And through reservation, we are making sure that people with all kinds of stories come into public institutions, correct those public institutions, so that those public institutions do not any longer become vehicles and instruments for perpetuating these wrong stories that are degrading people and are constricting the opportunities of people and making people conflict with each other. Therefore, once we reservation works, we come into these institutions and we come with our own stories and we destroy these false stories, we will build a new unity, bottom-up unity in this country, where this country will be a country where everyone has a good narrative, a good story about themselves. And the relevance of this the Varna caste system, which is simply a virus to create negative stories of others, will be destroyed. So let me, these are the 4 areas where I think we need a much more discussion, but we need to change the narrative at a social discourse level. We need to develop a new jurisprudence challenging these false ideas of efficiency and merit that we are confronting now, and misrepresentation of ideas of equality, misrepresentation of ideas of merit, and we must help to develop, as I indicated, a correct jurisprudence that will protect promotions for SCST and will also restore protection, reservation in promotion for backward classes, and will also ensure that all this program of restoring the opportunities that were lost to us will be successful, as envisaged by Dr. Baba Sahib Ambedkar and all the others who built this constitution. Let me stop here and request Justice Eshwaraiah to kindly share his thoughts with us. I'm sorry for speaking a bit longer than I expected. Justice Eshwaraiah, sir, let me, sorry, apologies, sir. Let me unmute you. Oh God, I'm second. Getting a lot of these. Let me withdraw my 1 second. Give me 1 second. I need to. Yeah. I need to stop sharing. Okay, stop sharing. Now I will unmute Justice Eshwaraiah. So apologies, sir. I so you may kindly unmute, sir. Justice Eshwaraiah, sir. Let me just. Hello. Not able to. Justice Eshwaraiah, sir. Sir, I'm unmute. Let me unmute. Okay, sir.
Now I'm able to. Sir.
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
Again, it is at a mute.
Sir, 1 second, sir. Now please unmute, sir. Yes, sir. Yes, sir. Again, yes, sir. Yes, sir. Yes, sir. It's clear.
Am I audible, sir? Audible, sir, now?
Yes, sir. Yes, sir. Yes, sir.
Thank you, sir. Thank you, sir. My sincere regards to the most elderly, the well-wisher, and who is concerned for the constitutional rights of the majority people of India. That is Ms. Indira Jaising, the senior advocate of the Supreme Court, and we feel proud of seeing and listening with regard to our experience and our concern for the constitutional and constitutional rights to the 85% of the people of India. And therefore, we are beholden her. And Dr.K.S. Chauhan, who is well experienced in all the social justice matters and constitutional matters, and the teacher of all of us, Professor Dr. Mohan Gopal, is always he gives innovative ideas, and he is a link pin for the Supreme Court and the lawyer strategy, and all the legal luminaries who are present here. Really, my sincere regards and regards. Then, as the senior most sister, Indira Jaising ji said, she has analyzed both Chauhanji and Professor Mohan Gopal, analyzed uniformly and symmetrically that the Article 14 read with Article 16(1) are enough to implement the constitutional, the fundamental right of the equality in proportion to the population. Therefore, Article 16(4) and 4A is only the enabling provision. And as Subbarao said and Indira Sani said, even Article 16(1) itself is sufficient to have the reservations in favor of the backward classes. Backward classes, as rightly stated, that is SCs, STs, the other social education backward classes, all are called as backward classes. Then, unfortunately, the backward classes were having no reservations till the I think till when it was Article 16(4), no reservations were in the beginning, and thereafter only promotions, because they were wrongly interpreting the Constitution. Then promotions, they made a provision for the promotions only in the year 1995. 1995 by Constitutional 77th Amendment. Even if you, as Dr. Chauhan said, even in the initial appointment also, there is no adequate representation in proportion to their population. And though there was a reservation from the beginning, from the date of the Constitution came into force from 1950 in the Parliament and the Rajya Sabha and assemblies, but there was no reservations in the local bodies, even in the local bodies, and reservations in the employment and the education. So later, the reservations have been started implemented because they were misinterpreting and misunderstanding, and conveniently, the Constitution was explained in a different manner. And therefore, now the as Dr. Chauhan rightly said, there is a de-reservation. Insofar, at least SCs, STs, there is a carry forward in BCs are concerned, as Mohan Gopal said. So from 1993 onwards only, the reservations are started implementing 27%, but every year they are re-reserving continuously from 93 till today. That is nearly about the 27 years. No reservations are being re-reserved. Now the question of promotions, considering the promotions, the only fundamental principle according to me is the adequate representation means in proportion to population only. Therefore, 16.1 doesn't say the adequate representation. It says 16.1 only says shall be the equal opportunity of all citizens in the matters related to employment or appointment in the office under the state. As senior counsel Indira Jaising said, equal representation means it has to be read along with Article 14. Therefore, it should ultimately it should be in proportion to the population only. In proportion to the population only. That should have been the interpretation. Had the Professor Indira Jaising or Mohan Gopal or Chauhan or some of our have been the Supreme Court judges, maybe we would have properly and truly interpreted the constitution, but unfortunately the combination in the higher judiciary is not consisting of the backward classes. Therefore the constitution is rewritten by the Supreme Court, and the government which could not be achieved politically are being achieved through the courts, very unfortunately. Because we are not enlightened and we are not united and we are not able to then protect our rights. Therefore, now the trend is going very wrongly and alarmingly, leading to really take us to the backward, as Professor Mohan Gopal said, by virtue of the creamy layer, then make a real backward. By virtue of the 10% EWS, make us a real backward class. And by virtue of the denying promotions and even the de-reserving the backward classes and not providing the reservations in the 50% of the PG medical courses and privatization of the many things. And therefore, my opinion and very strong feeling should be is that there should be a proportion representation in the employment, in the political, in even in the local bodies also. Now, as Professor Mohan Gopal says, then others says there should be the equal opportunity. Means how does suppose a giant family is there, when they divide, whether it is a deaf or dumb, he gets the equal share in the property. Therefore, this country is built by each one of us, that is SCs, STs, mainly backward classes, by their sweat and by their efforts. Therefore, we should have the equal opportunity in all executive, legislature, and the judiciary employment. And that is the reason why the provisions, though, have been made with good intention, but unfortunately they have been misinterpreted. Now the share privatization. Now privatization is now Adani, Ambani. At whose cost they have become multi-millionaires? And who is working? Why not there shall be a reservations for the SCs, STs, backward classes in Adani and Ambani and other under companies also. Other companies also. Then why this privatization without having reservations? And why the hoodwinking the system of the government of India not to have the caste census? It's only to deprive our right. The caste census is one of the most important thing, and the data, and where from the data, what is the data required? What is the empirical data you require for considering the promotions? When there is no, it is a common knowledge for each and everybody. In the initial recruitment itself, it is not there. Their percentage is not there. Even the population of the scheduled caste, scheduled tribes, backward classes have been increased, and you don't implement the reservations in proportion to the increased population. increased population, and now though constitution has been amended by Article 16(4)(a) for promotion, but Supreme Court comes in the way on the ground that this applying the Nagaraju that they should have been adequate data and the adequacy. Where is the question of adequacy? Mr. Dr. Chauhan said, with regard to adequacy is concerned, many states, not even 10% is not there in the initial recruitment. Where is the adequate representation in the promotion post? It is merely because they have a power, and they have power. Unfortunately, the judges are not being punished under the contempt of court for disobeying the orders of the Supreme Court in Indra and in this case. Merely they can disobey and escape because they are not amenable to the contempt of court. Therefore, it is very serious questions before us, and this legally and the socially, and by having a movement as a movement of this the social justice movement as a second national movement, only we can achieve these reservations for the reservations even in the promotions for the SCs, STs. So then there are many stalwarts who are experts in the constitution, but these are the very few of my comments. Therefore, I thank you, Professor Mohan Gopal, and all other my dear and near for giving me the opportunity. Then now now the government rewrites the constitution to go back. I fully agree, Professor Mohan Gopal, that it is only reservations means restoration of our rights, and even constitution doesn't accept that. The constitution contemplates the mercy, the compassion, the love, the equality, the freedom, the justice for all. But why this they divide us that you are the untouchable, you are a scheduled caste, you are a scheduled tribe, you are denotified tribe, and you are so many. The reservations are only to bring equality, to make this country as a casteless society. How does casteless society? That is ultimate objective of the constitution is to create a casteless society. When does that casteless society comes? When we also become equal to them. Then there is a intercaste marriages, interreligious marriages. There is no fiction. There is no perception in the mind of everybody that he is a lower class, he is an upper class, he is a working class. There should not be any prejudice in mind of anybody. Then only the casteless society, then equality will, unless the equal opportunity is given all walks of life, this kind of egalitarian or utopian society cannot be built, and our dream will not be fulfilled. Therefore, I thank Professor Mohan Gopal, all of you. Thank you.
Thank you, sir. Thank you for your, as always, very wonderful remarks. And may I now request Mr. Mavuji to kindly share his thoughts with us. Chairman, Honorable Chairman of the Kerala State Scheduled Caste and Scheduled Tribe Commission. Mr. Mavuji, I have to unmute. 1 second, sir. I have to unmute. 1 second. Not able to find Mr. Maoji. I have a very large number of participants. So find I'll just call Mr. Maoji. maybe he's under some other name.
Till Maoji comes, then I really, it's a great fortune to have Mohan Gopal to create a theory, a philosophy. And our, there are many organizations in all over India.
Madam, may I, sir, may I request Madam Santhamma to speak, and then I will get in touch with Mr. Maoji. I'm not able to reach him. Madam Santhamma, will you? May I request you, Mr. Maoji? Are you on the online? No, okay. അപ്പം ഞങ്ങൾ മാഡത്തിനെ വിളിക്കട്ടെ, മാഡം ശാന്തമ്മയെ വിളിക്കട്ടെ. ഓക്കെ, അല്ല നെറ്റിൽ വരികയാണെങ്കിൽ ഒന്ന് എന്നെ വിളിച്ച് പറഞ്ഞാൽ മതി. ശരി, താങ്ക് യു. Mr. Maoji has a problem with net connection, so Madam Santhamma is online. May I warmly welcome Advocate Kerala High Court and very, as I said earlier, an advocate who fights at the forefront of the struggle for social justice, Madam P.K. Santhamma. Please, ma'am.
Unmute.
Yes, ma'am. It's unmuted, ma'am. No, now according to me, on my side, it's unmuted, ma'am. Yes, I can see you also, ma'am. I could hear you earlier. Yeah. Okay, now again coming as unmuted. Okay, can you just unmute on your side, ma'am? Ma'am, can you just unmute on your side, ma'am? Hello? Yes, I can hear you now. I can hear you now, ma'am. Hello? Ma'am, you're unmuted from our side. Ma'am, are you, hello?
Sir, please make a call her.
Yes. I'm trying to call her. She came on, and then I had some connectivity problem.
Maybe she was not able to listen by the time, sir.
Ma'am, can we, one second. I'll ask somebody to follow up. So let me ask the next person to speak, and then we'll come back to Madam Santhamma. Ms. Vidyuth. Hello. Can I request? Yes.
Sir, can you hear me now?
Yes, I can. Louder, little bit louder, but we can hear you. Yeah.
Okay.
Request Mr. Vidyuth K.S, faculty member, Government Law College, Kozhikode, and active leader of social justice movement to speak, please, Mr. Vidyuth.
Thank you so much, Dr. Mohan Gopal, sir. I hope I am audible enough.
A little bit louder. The volume can be a little bit louder.
Is it okay now?
Yeah.
A very good evening to you all.
If you are audible, sir.
I hope my
Yeah, listening you, sir.
hello?
Good evening, sir.
Gopal-
Please unmute everybody.
Gopal,
Lot
sir.
of disturbance are coming. Yeah.
Thanks, Mohan Gopal sir and others for organizing this type of meeting. For this meeting, we learned most about reservation.
Gopal sir കേൾക്കാമോ? മറ്റുള്ള ഓഡിയോ ഒന്ന് കട്ട് ചെയ്യണം. You are not audible. You are not audible, sir.
Cut any audio on your side with you. Some echo is coming back. Some echo
No,
is
actually
coming
not
back.
from my side. Not from my side. Some other audio.
Mohan Gopal sir, please listen to me. Actually, this problem is arising just due to that all mics are open. All other participants are opening their mic. Please mute them.
Yes, I've muted all, sir. I've muted all. I've muted all.
Sir,
Sir, I think still
you disable. Sorry, you please disable the unmuting by individuals, because individuals are unmuting and speaking. Yeah.
No. Yes. Oh, that's right. That got yeah. Yes. Vidyuth?
okay. Am I audible now, sir?
Yes.
Another mic is also on.
Okay.
This is coming up. Okay. I think one Dr.S. Rajashekharan, his mic is on. Dr.S. Rajashekharan. Then Gurbachan HK means Jagadish Prasad Dhinwal. There are many whose microphones are on. Could you all please switch off your microphones?
അല്ല അത് എനിക്ക് കാണാം, എനിക്ക് കാണുന്നതിൽ വേറെ ആരും ഓൺ ആയിട്ട് കാണുന്നില്ല. According to here, I've muted all. You are on, and I sent you a request for unmuting. You're the presenter. You're designated presenter, and if you unmute yourself. There's only one noise, one person that I've locked the meeting now, and there are many people waiting outside, but I've locked. Yeah.
A very good evening to you all. Am I audible to you? Could you please respond to me?
Once again, we are unable to we're interrupted because there are a lot of some mics are on. Can you please check and unmute all the mics, please? Mute all the mics. Can everyone please mute all the mics?
Sir, it can
Yes,
be done by only host, sir. You can do this thing, sir. You can mute it
Sir,
on this mic, sir.
Mr. Verma, I have done that several times, Mr. Verma. This is not new to me. I'm aware of that. I have muted all several times. Okay.
Sir, let him proceed the
not that
talk.
I've not
Then
done
we will
it.
see, sir.
Yes.
Let him continue the talk, sir.
Yes. Yes, please. Yes.
Okay. Thank you so much, Dr. G. Mohan Gopal, sir. I hope I'm audible enough. Even though that some voices are coming over.
There is one. There is only one. See, one participant is Mr. Vijay Singh. Mr. Vijay Singh is not muted.
KC Menon.
Vijay Singh is not muted. So I'm going to once again press mute all, and let's see if that will work. Anyway, why don't you proceed, Vidyuth? Let us do the best we can, because we are unable to. See, next meeting onwards, I will only make it YouTube live, and I will restrict the access to WebEx to only the speakers. So that will be our solution. But this time, let's finish it. Yeah.
Okay. Thank you, sir. Very good evening to you all. I know that my voice is louder enough.
Yes.
Question of reservation.
Hello.
No, I think we'll have to.
क्या program था क्या आज?
A lot of louder noise, disturbing me, sir.
चालू नहीं हुआ?
We can't.
क्यों?
Or why can't you remove those candidates?
8 8:30 तो वो अभी तो एक वो चल रहा है कोई कर्नाटका का SC/ST प्रमोशन वाला, तो वो लोग इंतजार कर रहे हैं. मैंने कहा क्या हुआ?
Yeah, I'm just I'm just removing people whose mics are not muted. Just give me 1 second. I'll just get who whichever mic is not muted. I'm just going to
KC Menon on the line, sir. KC Menon CC. KC Menon CC it is.
Santhamma madam is seeking for admission.
Yes. 1 second. those who are not here can watch on YouTube live. I'm just putting out all the people who are whose mics are not muted.
Sir, Mavoji sir wants to come in. You blocked him, sir. So he wants to come in.
Yeah, no. One second. I think Mr. Murugan, I'm not sure why you are not muted, because I muted everybody.
Sir, just Mavoji sir called me, so he wants to come in. He has been blocked now.
No, but how did you unmute yourself? Because I have not allowed attendees
you are not disabled, sir. Please do that.
I have done it, but somehow it's not okay. Now he's out. Others can just watch on. Others can just watch on. The main problem we are still not able to expel. The main source of the noise. Can Vidyuth, can you tell me any names of mics that are open?
Gurbachan. Jagadish Prasad Kapilwal.
Yeah.
Jagadish Prasad, then Jignesh G. Then K.C. Meena.
Yeah.
Lakhanlal Chauhan.
K.C. Meena.
Then Padmavati Dhanavantari.
That may be the source of the noise.
Yeah, that's all.
But that other noise is still there.
Yeah, still there. I don't know from where. Sir, അവരെ ഒന്ന് പെർമിറ്റ് ചെയ്യാമോ? മറ്റേ മാവോജി സാറും ശാന്തമ്മ മാഡം.
അതെ ഞാൻ ഇതൊന്ന് തീർത്തിട്ട്, പക്ഷേ ഈ നോയ്സ് നമുക്ക് we are not able to get rid of. It's all blocked, all muted.
സാറിന്റെ എന്റെ ആയതുകൊണ്ടാണോ? നമ്മുടെ ഓഫ് ചെയ്ത് നോക്കണം.
Okay, go ahead, Vidyuth. But that is still not on. I'm going to just tell more people.
बाबू के मोबाइल का चार्ज खत्म हो गया.
No, I apologize to everyone. Next time we will make sure that the audience is only through YouTube live, because then this problem will not come. Are we okay now with the noise? No.
It is there. Songs are coming. Songs and
Yeah.
it's like noises of children.
But you're not seeing anything unmuted, no? And I'm actually just going to almost see, the point is, the difficulty is I'm not seeing 136 people. See, there are still 136 people left, and I'm not seeing all of them here. No, I'm seeing all of them, but they're all muted. I'm going to do we had a huge number of people. There is somebody wo Chauhan sahab वो आपको पता हो कोई हिंदी बोलने वाले एक माइक ओपन है, वो यहाँ दिखाई नहीं दे रहा है, लेकिन बच्चों का आवाज वगैरह आ रहा है. Okay, Vidyuth. Mr. Mahoji is here.
Mohan sir.
Mohan. Oh, who is speaking? Dr. Mahavir. Okay, now it is now that is gone. Vidyuth.
Yes, sir. Can you hear me?
Yes, now that noise is gone.
Okay. Thank you, sir.
Please resume.
Okay.
And
So,
then we will I will contact Mr. Mahoji. But you please finish, and then we will. Yes.
Good evening to you all. I'm really sorry for the inconveniences caused. So when we think about reservation in India, we have certain problems relating to the concept of reservation that I would like to explore from my perspectives, of course, by relying upon certain ideas of America. The three problems, or four problems rather, I have identified is the problem of evaluation, firstly, and secondly, the problem of understanding, and third, the problem of lack of empirical materials, and fourth, a problem of conspiracy. So all these problems are related to reservation when it comes to the implementation or even conceptual understanding of reservation. What are these problems? I'll explain. The first problem is the problem of evaluation. That means in our society, there is a class of, or there is a group of people who believe that reservation is bad. Reservation is evaluated as bad. And they have many reasons to justify this evaluation. I have come across some of the arguments through certain meetings which I have gone through earlier. And also I have seen some of the comments from the messages of our own group, that the session which is going on, which is not at all connected with an understanding of the concept of reservation. I'll just mention few for illustration. One is that reservation affects merit and leads to inefficiency. Second is that reservation excludes poor and needy people. Third, it creates a creamy layer class and retains a creamy layer class, which is wrong. Fifth, reservation promotes casteism. Need for reservation. Argument is that reservation is against Article 14, 15, and 16. So these are certain arguments which is leveled against reservation to attack it. And reservation is evaluated as that based on this ground. Second problem is the problem of understanding. And I would say that this kind of evaluation, reservation as bad, comes from misunderstanding or the problem of understanding. Understanding has two aspects. One is understanding the concept of reservation, or there is no conceptual clarity, or there is a misconception as to what is reservation. Second aspect of understanding is that there is no understanding from the empirical side. What is the reality? What is the conditions which is existing in India as a society in relation to education as well as public employment? So I would say that we need to understand the conceptual scheme relating to reservation for the purpose of better evaluating the scheme of reservation. And why we do not have a conceptual understanding is because of the final problem that I would say, the problem of conspiracy. That is, there is a conspiracy deliberately to attack reservation because of certain reasons. So that is what I would like to examine.
Can't hear you, Vidyuth. Bandwidth, I think. Can't hear you. Vidyuth cannot hear you. Vidyuth cannot hear you. Cannot hear.
So it's a historical understanding that we require. And we know that we had a society wherein there was suppression, there was exploitation, and there was inhumanitarian treatment, which is meted to our people. So that social organization had a worldview. Worldview was that there are two categories, or there are certain categories of people, and there is a higher category of people called as Brahmin, which has superior abilities, which has merit, and there are avarnas, or those categories of people below the ladder who is not having any merit, or who is not having any capabilities, not having any efficiency, and who should not be given better opportunities, and who should not be placed in important positions as far as our society is concerned. This worldview was the worldview of Savarnas, or we can call it as the Brahmanist worldview. And we fought to liberate us from this worldview or Brahmanist worldview, and we have decided to create a new social organization which values equality, liberty, fraternity, and also which confer equal worth to all the individuals. And we need to understand that to constitute such a society, to organize such a society, we require an instrument or agency of law to support us. So that is the relationship between law on the one side and society on the other side. So for the purpose of fulfilling or living,
Vidyuth cannot hear.
fraternity,
Cannot hear. Cannot.
Hello?
Your voice is breaking. Yeah, on bandwidth. Yeah.
Oh, I don't know, sir. Actually, can you hear me now?
Are you're on the mobile, is it?
No. I am in my tab. It's tab. I think there is some. Hello, can you hear me now?
I can hear. In the middle, I could not, but now I can.
Hello, am I audible now, sir?
Yes, that much better.
Okay. I don't know. Probably I don't know from where the voice cut. No. The point I just want to make is three. One is that we had a society wherein there was suppression, exploitation. Sir, it is that there is a echo upon my side, and I cannot hear what I say. Some voice is coming back. Hello.
Go ahead.
Hello, am I audible now?
Yes, please.
Okay, so in between, I don't know from where I have left off. The point I was trying to make is that what is the relationship between law and the society? So I was saying that law is an instrument or law is an agency to realize or to fulfill certain values of a particular society, which that society considered to be so important for social organization. And we had in our past, we had a very, very bad society as far as avarnas are concerned. Society which has suppressed us, a society which has exploited us, and a society which has never considered the values of human dignity and human worth. Was designed by Savarna community, and this is the society we call it as a Brahmanistic society. So when we fought for freedom, our intention was to realize a society wherein there would be liberty, equality, fraternity, and which would value the equal worth of all individuals. So that conflict between Savarna and Avarna was there, and Savarna as a community was the beneficiaries of that social designing. So pre-independent society was a society which was beneficial for Savarnas. All the resources they have acquired, and they have created all the mechanisms for exploiting us. So as far as we are concerned, we want a different social organization, and we have designed our constitution for that purpose. It is in this context that you need to evaluate or examine the constitutional principles. So at the very beginning, in the preamble itself, we have made clear what are the values that we want. We want equality, liberty, and fraternity, and we want to design such a society. What is the problem with this? What is the problem with this is exactly the predominance of Savarna in major positions, the predominance of Savarnas in the utilization of resources, and they are possessing almost all the powerful positions as well as significant resources that should be used for the development of people. What we want to achieve is social justice in the society, and it is precisely for the purpose of achieving social justice that we have designed the constitution as it is existing in the particular form. So when we examine the problem of reservation, 16(4)(a) is very clear in stating that 3 elements has to be met with. One is that the state has the power to create a reservation and there should be inadequacy of representation in the services under the state, and the state should have an opinion that the particular community, scheduled caste or scheduled tribe community, doesn't have adequate representation in the services under the state. Now, what we need to understand is that adequate representation, as stated by Dr. Mohan Gopal sir and the former discussers has said, that it is an empirical question which has to be established by the state before deciding whether the state should offer. Hello?
Yes, please go on, Vidyuth. Our time is running out.
Hello.
Yes, we can hear you, Vidyuth. We can hear you, Vidyuth, because we're getting a little bit late. So, are you having any problems connecting? Hello, can you hear me? Hello.
Oh, am I audible now?
Yes, please. Yes, please. And if you
sorry,
can just, give the main points and let because we are running very late now.
Yes. Actually, I have a lot of disturbance, so I have maybe I have in between also there were certain frustrations. So I do not.
So
know
what I will suggest is, please make your main points, and I will request that we can you can send me a tape of your presentation, which I will upload on YouTube. Okay?
No problem, sir. Yeah.
So now you can just make your main points and then conclude.
Yes. Yeah. So my point is simply this. Yeah. My point is that law and society has a relationship, and the relationship is that law has to be designed for the purpose of achieving certain values, which our constitution has clearly laid down, not only in the preamble but throughout the body of the constitution, and that is equality, liberty, and fraternity of the individuals. So it is the individuals which is given value in the constitution, and the problem that exists in India is that a certain class of people has overpowered another class of people like Avarna and has captured all the public places and resources, and it is an injustice as per our view. So we wanted to address this social injustice, and it is for that purpose we have Article 16(4)(a) by way of a mechanism called reservation. So why reservation is required? Because reservation, if there is no reservation, it would result in inadequate representation, and it won't improve the lot of the people, and there won't be an instrumental effect to spread education. So what we intend through reservation is that if reservation is made as a mechanism, then we can ensure that people from SC and ST would get at least representation through reservation, and that will improve the lot of the people, and that also will have an instrumental effect to spread the need for education, because for the purpose of getting representation, the institution where these people are placed in, because it adds to the diversity of the institution, and the experiences of these people could be taken into account, and that will add to the quality of administration. And also, it is an essential part of democracy. So this reservation of the people has to be seen from the side of democracy, as defined by Ambedkar as a form and method of government whereby revolutionary changes in the economic and social life of the people are brought without any bloodshed. And Ambedkar has said 6 preconditions should be there for a democratic way of life. One is that there should be elimination of inequality. Second is that there should be existence of opposition. And third is that there should be equality in law and administration. Fourth, there should be observance of constitutional morality. Fifth, no tyranny of majority over minority. And seventh, public conscience. So only when these 6 elements are present, then we can say that that particular society is a democracy. So we must understand that reservation in public space and promotion would place SC/ST community into the positions wherein they can influence policy making, and they can influence even law making, because law making is not only done through legislation, but it is also done through delegated legislation, or through the creation of statutory instruments. So definitely SC/ST people should be represented, should have representation in legislature, as well as high official capacities or offices. Why? Because then only these people can influence the direction of the policy making. If these people cannot influence the direction of the policy making, then we cannot say that it is a democratic society. So our democracy requires the representation of the people, and it is a necessity, because otherwise we do not have a democratic India. And democracy is a primary value which should be valued. I'm sorry, because of these disturbances and short span of time, just stopping. So as Mohan Gopal sir suggested, I just record my video of presentation. I will send you. Thank you, sir.
Thank you very much, and apologies to you for all the disturbance that was caused. And now, may I go back to Mr. Maoji and hope that our technical issues of his coming in are sorted out. Mr. Maoji, I can see you online now. And may I request you to speak, sir? You're not muted also. And you're the presenter. Mr. Maoji? You're not muted and you are the presenter. So let me try Madam Santhamma, and then we'll come back to Mr. Maoji. Madam Santhamma, can you hear me? With Madam Santhamma, the issue is, yes, we are now. Please unmute, ma'am. Please unmute.
Mute.
Yes. We can hear. I can hear you.
Oh, okay. Thank you, sir. I'm very sorry that I was a little uncomfortable.
My apologies for these kind of large webinars. This is quite common, not unusual, but sorry about that. Yes.
Oh, okay. It is matters.
Yes.
Okay. Very
Thank
good.
you so
Good
much
evening.
for joining us.
Okay. Good evening to you all. That is first of all, I must thank that for including me in this webinar, and I thank to Mohan Gopal sir, and I must thankful to the group for selecting this subject, that is denial of fundamental right of SC/ST to reservation in promotion. I'm very much thankful to the selection of the topic. Anyway, I'll only confine to the points because it is nearing to 9 o'clock. So I must, after hearing all this, I must say that this this reservation, that is in Anjan Kumar versus Union of India. It was in 2005. It was found by observed by Supreme Court that reservation is not a bounty. So it is a constitutional right guaranteed to the scheduled caste, scheduled tribes, and the backward classes. So and also about the caste, I just going a little faster. That in the caste is so I already I said in many places that caste is Punitrai versus Dinesh Chavdari in 2003. Supreme Court has said that caste is ingrained in the minds of Indian community. So it is deep rooted. So and we must come to Article 14 that we all know that it's equality before law and equal protection of law. So Mohan Gopal sir said and many others said that is Article 16.1, that is whether it is Article 16.4, that is whether it is an exception to Article 16.1. Yes, it is said in State of Kerala versus NM Thomas that it is not an exception. And also in Indira Saini also it was reiterated. So my opinion is, or my point is that unless 16.4 is there, this Article 16.1 will not work, and Article 14 also will work only if the on the addition of Article 16.4. Otherwise, equality will not come. That people are in this caste system. There's a discrimination. There are in the different sections. Then there's the equality. If equality we want to bring equality, then all the ingredients should come. Article 14, Article 16.1, and Article 16.4. And I straightly go to Article 16.4a. That is reservation in promotion. That is, we know that is 77th amendment was brought in. That is in 1995. That is and that is in promotion, reservation in promotion to all class. Thereafter, in the 85th amendment, it was some more added. That is promotion to any class with the consequential seniority. That is to any class. That is promotion to any class with the consequential seniority. So I must say the government was so cautious that to overcome many other judgments, as many others said earlier, that that is the barrier, putting some barrier, so putting some hurdles. That is with the appointment or promotion of the socially educated backward classes, especially scheduled castes and scheduled tribes. So the 85th amendment and this 85th first amendment also brought, that is to carry out the vacancies, and also to get over the ceiling of 50%. So we have to say that these three amendments were brought or have been brought in the constitution to protect the interest of the scheduled caste, scheduled tribes, and other the backward classes. So backward classes are not coming in these three, but the government was cautious. So though the courts different judgments stood against the reservation policy, or stood against or spoke the disadvantages what is some observations stood against the scheduled caste and scheduled tribes. These amendments they were brought out for the rescue or for upbringing the scheduled caste and scheduled tribes and others. And just I also I said that is this is the Chauhan sir said that is directive principles are to be connected with or intermingled with the reservation. Yes, that is correct. Article 46 says that the state shall promote the educational and social and educational interest of the scheduled caste, scheduled tribes, and protect them or social ills and injustice and also from all sorts of exploitations. So it is the duty of the government, that is a duty is cast upon the government to protect the or promote the interest of the social educational interest of the scheduled caste and scheduled, and also to protect them from all sorts of injustice and also exploitations. So it should be read with this fundamental right is also read with Article 46. So government cannot escape that there is no duty upon us. So my opinion is, or my view is that it should be clubbed with Article 46. And the Article 16.4, that is while considering Article 16.4, that is the Supreme Court says it is an enabling clause. Then enabling also we have to find out the meaning of enabling, that is empowering. So empowering means the government is empowered with to make any provision for the for the adequate representation in promotion, that is by reservation. So government is, I must say, the government is duty bound to protect the interest of the scheduled caste scheduled tribe for their uplifting. That is, Gopal sir also said, that is uplifting these people. So the government should take responsibility. Government cannot evade the responsibility of this taking it as a fundamental right. Also, and we have seen that also already referred, that is Nagaraj case, Jaising. These two judgments brought very unpleasant situation or confusion, made confusion in the reservation of promotion, reservation in promotion to the SC/ST people. That is one said the quantified data about the backwardness. Then it is said the inadequate representation of the scheduled caste and scheduled tribes. Then it is said efficiency of administration. Then it is said creamy layer. And all when we go through all this, we can see that that is in creamy layer principle itself. We can see that in Indira case and also in Ashok Kumar Thakur case. In both the cases, the creamy layer principles, the Supreme Court said it is not applicable at all to the scheduled caste and scheduled tribes. Then how can they bring say that no, creamy layer is applicable to this? That is Jaising Singh. It was said that is all others. I leave all this. We leave all the other things, quantification data, inadequacy of representation. All we leave, but we say that there should be exclusion of the creamy layer. So how can they say that in a separate judgment, constitution bench, 9 judges, then how can they say that it is a creamy layer principle is applicable to the scheduled caste and scheduled tribe? And I admire the state of Karnataka, because they brought this Reservation Act in 1978 itself. They brought this act. And in 2002, it was the Reservation Act was again enacted, and it was questioned only because of the this Nagaraj case. It was questioned. It was challenged before the court. Otherwise, there would not be any problem. Anyway, I appreciate because it was the case was dismissed in 2017. They said no adequate no quantified data has been taken. No backwardness is proved. So the case is though their act is unsustainable. Immediately they constitute a committee, the Ratnaprabha committee. That was I noted here. That is that the committee was appointed 22/3/2017. Ratnaprabha was appointed, and in 27/5/2017 itself, Srimati Rekna Prabha submitted her report. That is, within 2 months she had submitted her report, and immediately next month, after 3 weeks, assent of the president was got. Then they published the said act in their official gazette on 23/6/2018. Within 3 months, they have completed all the procedure, and it was also challenged because to overcome the Supreme Court judgment, the state has made such an act, and it was questioned. So how speedily the state moved. It is the thing, or it is to be appreciated in my view. And with regard to creamy layer, I forgot one thing. And E.V. Chinnaya, we said that was also referred there. E.V. Chinnaya's case, the classification, further classification cannot be done in the scheduled caste list or scheduled tribes. That we can apply here. That is further a creamy layer cannot be excluded in the, and it is a homogeneous class. It can that these people cannot be excluded from the there's a further classification or further differentiation that cannot be made in the concept of scheduled caste or in the list, or their treating that homogeneous character that shall not be disturbed. And in this position, I am making some suggestions, because I said that it is to be read with Article 40 fundamental right. It is to be read with Article 46. Then some suggestions we have to make. That is, the government should be particular. That is the enabling provision. That is empowerment. The government has got the duty. The government cannot evade the duty. So government must take appropriate provision or appropriate action to make the relevant or appropriate laws in with regard to the appointment and also in the promotion of scheduled castes and scheduled tribes. They should make appropriate actions. I refer to Pavitra 2. That is there. The committee, the Reknaprabha committee, pointed out and or reported how the appointments are given. That is, in the last grade the service post, only sufficient number of SCs and STs, and when it is going up, there is no sufficiency. Only insufficient, or there is not at all an adequate representation in the top post. That was then a quantified data that was put before the court, and the court cannot say a different version. The court cannot deviate from the facts. Or specifically said, the court cannot deviate from that position. That Nagaraj is what observed in Nagaraj, that was all were complied there. So that is I must say that is the position of the representation of SC, STs and OBCs in all states and all the departments. Even I say it is either in the central government or in the state government. So government should take appropriate action or make appropriate law for engaging them or for uplifting the SCSTs in the service or different posts, even by giving direct recruitment or giving reservation promotion. Government should be government should do, or government is bound to do these things. So I must say that there is in 1994 there is a case, Madhuri Patil versus additional commissioner. That is with regard to the bogus certificate case. Then government found that so many people are making or getting bogus certificates and getting into employment. So Mavajis are better knows it, and court directed all the states to form or constitute a committee, a scrutiny committee, to find out who are the bogus certificate holders, and if they obtain such certificate, they should be thrown out of the service. So Kerala government also formed constituted an act. Many other states constituted acts to this to find out who are the bogus certificate and to throw the bogus certificate holders from employment and also in education. So I must say that the government has to appoint such commissions or committees or enact law for finding out who are the underrepresented, how much is the underrepresentation, and how much is the non-representation, or how much is the inadequacy of representation in service. So government should take appropriate actions or enact laws for get over or remedy or making the law or making how much it can compensate the loss caused to the scheduled caste, scheduled tribes, and other reserved communities. So government should be should bound to do that, with taking the provision of Article 46 also. And also if I say about our state of Kerala, there is a provision for by transfer promotion. In this there was no reservation at all. No reservation is provided in by transfer, only merit and ability. So it is I say it is for avoiding this the scheduled caste and scheduled tribes and other backward groups. So many appointments that is made in the service rules, that is part 2 of KS and SSR 28(1)(b). That is by transfer, by merit and ability. They can very well, others can very well exclude these reserved persons on account of this merit and also the ability. They can write that they are not having so much of merit, they are not having the ability. Then they can very easily throw out this the scheduled caste and scheduled tribes in promotion. So that is, and also I have conducted a case in with respect to public service, public sector undertakings. So there is a in 1985 itself, I'm going very speedily, pardon with me. In 1985 itself, there was a circular that register should be kept for knowing how much persons have been appointed or given appointment as or given promotion. But till date, after 1985, till date, such a register is not kept in such offices. So and C&A report said that pointed out each and everything, and we have made a case, and the government is saying that they are government is taking immediate steps for making appropriate arrangements or making remedial measures to make good these laws. So these are the problems that the SC/ST people meet in the sector. And also this by transfer also, I'm told that even legal assistance from the law department, they can apply for any jobs. Irrespective of the difference of department, they can apply for this by transfer for the promotions. So all are detrimental. These all are detrimental to the scope of promotion of this scheduled caste and scheduled tribes. And this when I said about this by transfer, that is the special rules are playing a big role. That is, general rule is there and special rule is there. So the importance is for the special rules, so that they can make any special rules, and the poor scheduled caste and scheduled tribes in service, they don't know what is happening there. They must be vigilant, but they are not, they cannot be so vigilant in all these matters, I think. So and they are not even coming up for challenging any such circulars. And in another case, the PSC has reported written to the government P&ARD that there should be promotion to the in by transfer promotions also. But the government said no, there is no need. After getting the advice of the Education General, it was said no, there is no need to give such. That is with the KS. There is no that legal opinion is that there is no need to make such arrangements in or made such provisions in those areas. So these are the things, and I must again I point that there should be committees and commissions be the appointed for finding out. There is the scheduled caste and scheduled race employees. They are not against that, and we all the people are supporting to find out in a which is the number, or what is the quantity, or what is the data, or what is the number of persons who are working in a very higher post. Every higher post, how many people from SC, ST and OBC are working. If such a data is taken, we can understand that how the SC, ST people are being deceived or defeated or cheated. So such measures are to come from the government. Government cannot escape from all these things. So the commission, Mauji sir is here, and so this role of commissions are very important. Either a national commission or state commission, they have got the power. Though they have got recommendatory power only, they can make suggestions to the government that in such and such places or such and such points there are lack of representation, and due to what the lack of representation, and that reasons should be brought before the government, and it must be emphasized or specifically put in government, and there must create a situation that the government has to comply those recommendations, and give directions to or national concerned departments to take appropriate actions for giving reservation in reservation in promotions of scheduled caste and scheduled. So the computing of data is very important, and this I wanted to say about the efficiency of administration and the merit. I must have, but due to the paucity of time, I am not going to that, because we all know that this efficiency, that is very well explained in the Pavitra 2 judgment, and also merit, that also explained. That we discussed in our article for 16 group that a person who is very well or scored high marks in LLB, sometimes they may not come in the profession, and then a person who has got less mark and he shines in the field very well, then that is also merit. So the merit cannot be measured with the academic marks. So that is to be dealt separately. So due to paucity of time, I am not lengthening my discussion. I'm very thankful to Mohan Gopal sir and the team for including me also in the discussion. And I know I was little fast because of the I say that it is due to the shortage of time. And I let me conclude. Very thankful, and very good night. Okay, sir.
Thank you, ma'am, for really a wonderful presentation. Deeply my apologies for the delay, and had connectivity problems with Audi coming on, and Nisha has informed me that there's very heavy rain and no electricity. Now we will move to vote of thanks to Yoshi, who is one of the organizers. Just say 2 words and then conclude. First of all, I want to apologize for the reasons beyond our control. There were, I think, a couple of people affected. When we have very large events, this kind of I've been part of some other events where we've actually had to shut down the event. But in this platform, we are able to scout such people and restore some order. But next time, I think what we'll do is we will expect a very large audience, audience on YouTube. It's unfortunately no time, it's 9:15 discussion. But we had very rich, detailed presentations, and I did not want to curtail anyone because, frankly, they are building a record. They are taking a recording of all this, they are putting it on YouTube. Madam Indira, Jaising, and Dr. Chauhan. Santhamma, all made very detailed, Eshwaraiah made detailed presentation. I just want to curtail that. And myself. Thank you very much. I think where we are now, if I can conclude, is we have identified that there are that this whole area of reservation and SC/ST reservation, which was a little bit of a sacred cow in 2006. No one questioned or attacked SC/ST reservation. But now they're bringing in some of the instruments used to curtail OBC reservations are being applied against SC/ST reservations, and it is being slowly curtailed, and the restrictions are increasing, as I pointed out, that chart I put down. So it's time for us to effectively resist this, and we need new arguments. That's what I was trying to say. We need new arguments to counter. We know the strategy. The strategy is by using Article 14, by using merit, by using division of society, and also the idea of economic backwardness as the problem, so that we can bring in economic weaker sections from other non-backward communities. And so we have to counter that. We have to prompt and we have to indicate that the program of the Constitution, which includes reservation and adequate representation based on population share, which emerged from the Constituent Assembly, is the only prescription for uniting the society. Because unity has to come from the hearts and minds, not by force. And it has to come based on equality and freedom and fraternity. And that will only come when these inequalities are destroyed. The source of our division is inequality and injustice. So when inequality and injustice are removed, that's the only way we will all unite under the vision and principles of our Constitution and make our country strong and make our country effective, and a country where every single person will enjoy dignity and freedom and equality. That is the vision of the Constitution that we must, unhesitatingly and without any fear or any compromise, struggle to protect and realize the Constitution. Thank you very much to again to Madam Ms. Chauhan for patiently being Eshwaraiah, Madam Santhamma, who has also been very yes, forward to the next trying to have a webinar every month. Over to the next webinar. Thank you so much. അതൊന്ന് വെയിറ്റ് ചെയ്യണേ, വെയിറ്റ് ചെയ്യണേ.
Good evening, everybody. As you all know, that we are in the, I would first of all, I apologize everybody, especially our distinguished guests and speakers, for the disturbances and the technical issues during the discussion. I think that everybody knows that such a large meeting, it is common, but I think that our leader, Professor Mohan Gopalji, is taking very much pain to manage it. Anyhow, I am concluding my words. I would like to express our sincere gratitude to Senior Lawyer of Supreme Court, Madam Indira Jaising, and Dr.K.S. Chauhan ji, and Justice Eshwaraiah ji. In fact, he is our leader. He is leading us, advising us, and all other distinguished guests, Shri Vidyuth and Advocate P.K. Santhamma, respected Maoji. All are our members of this group also. Anyhow, I express our sincere thanks for their participation, and in fact, I would like to express our sincere thanks to Professor Mohan Gopalji. Even though we are all associating him, he is doing everything alone, but we are all behind him. I request everybody to join together. We have to work, we have to fight, we have to join together. Once again, express our gratitude and thanks to all the participants. We are proud that this is our third webinar. Nearly 1,000 participants are actively participated through WebEx and YouTube Live. In fact, we are proud. We are everybody to associate in future also. Thank you everybody.